All right, well, good morning. Welcome to the board meeting of the Osteopathic Medical Board of California. This meeting is being held on September 23rd, 2021, and the time is 10:02 a.m. This meeting is occurring at various locations pursuant to Executive Order N-25-20 dated March 12th, 2020. The meeting will be conducted using the following guidelines. All participants will please mute their microphone or phone during each presentation of the agenda topic. Board members who wish to provide additional comments should select the raise their hand feature next to their name. This will alert the host and chair that you have additional comments. At the conclusion of the discussion from board members, we will ask for public comment. At the conclusion of the discussion period, I'll call for the vote if necessary or move on to the next agenda item. All in attendance should keep their comments specific to the agenda item being discussed. An opportunity for public comment for items not on the agenda will be provided. Please be advised that during this comment period, the board cannot engage in discussions or take action on any matter that is raised, except to decide whether to place the matter on the agenda for a future meeting. We will now establish a quorum. Machiko, will you call the roll, please?
I will. Good morning. Gora Damian,
Here.
Cyrus Buhari,
Here.
Elizabeth Jensen,
Here.
Amesh Patel,
Here.
Claudia Mercado, Denise Pines. You have a quorum.
Present.
All right, wonderful. I'll just take a quick moment to welcome Denise Pines to the medical board. I think this is the first meeting, and it's a pleasure to have you join our board. You have a prestigious past, I think, serving with the Medical Board of California and all the work that you've done and all the work that you continue to do, and it'll be very nice having you on board.
Thank you. I'm happy to serve.
Wonderful. Okay. With the quorum established, we will move on to our next agenda item. So agenda item number 2 is public comment on items not on the agenda. During the meeting today, public comment is welcome on any agenda item as the item is taken up by the board. Under the Open Meeting Act, the board may not take any action on issues raised by public comment that are not on the agenda, other than to decide whether to schedule that issue for a future meeting. In order to allow the board sufficient time to conduct its scheduled business, the board will limit the time given to each person to 2 minutes. It's not necessary to repeat statements or views of a previous speaker. It's sufficient to state that you agree. As a reminder, please do not disclose details of active enforcement cases or licensing matter, as this may compromise the board's ability to hear the case in the future. The board appreciates your cooperation and assistance in meeting its legal mandate. At this time, are there any public comments not on the agenda?
This is the moderator. For today's public comments, we will be utilizing 2 features in WebEx, both the question and answer feature, which you will hear me refer to as the Q&A, and the hand raise feature. To submit a request for comment through the Q&A, you will locate that Q&A icon on your screen, which looks like a question mark inside of a square. Type comment into the text box that pops up and submit that to our panelists. You may also utilize the hand raise by hovering over your name and clicking on the hand icon that appears next to it. If you use the hand raise feature, when you're done speaking, I would ask you to please repeat that process to lower your hand. And as a reminder, today we are in a new WebEx environment that I don't believe your program has used before. So as you see, we do have live closed captioning, should be appearing on your screen. If you would like to remove that from your screen, you can do so by clicking on the closed captioned icon, which typically appears in the bottom left corner of your screen. And it is also typically associated with what looks like a little robot icon. It looks like a little cassette tape. And if you click on that little closed captioning icon, it should remove the closed captioning from displaying on your screen. You can then also click that icon to have it reappear on your screen. And I think in most instances, most people should be able to click on the box where the closed captioning is appearing and move it around your screen if you'd like it to appear in a different location. With that, we do have a couple requests for comment. Our first comment comes from Kathleen Tarr. Kathleen, I sent you a request to unmute your microphone. You should receive a pop-up at your end, and if you simply click on the Unmute Me button, it will unmute your microphone. Just allow a moment for WebEx to make its brief statement before you start speaking.
Okay. Should I be waiting for statement?
You're good to go.
Okay.
We've tried to turn off the little statement that gets played, but I'm not sure if it's still there. That's why I said that, but you're good to go. We can hear you.
Okay, thank you so much. I'm sharing my concern that OMBC is falling a little short in its mission to protect consumers and promote the highest professional standards in the practice of osteopathic medicine. I'm talking about a closed case, so it's not something that's ongoing. My physician had stated in writing, I am sorry you're not happy with my care, so I'm taking my name off your chart. The reason I was not happy, it was racism, but I only brought to the OMBC the open and shut case, I thought, of patient abandonment. Instead, my experience with OMBC has been thus. I emailed OMBC on March 26, 2020 to check whether my January complaint against this doctor for patient abandonment had been received. OMBC did not respond. I called OMBC on April 7th to check status. No answer, so I left a voice message. My call was never returned. By letter dated April 8th, 2020, OMBC confirmed receipt of my complaint. In reply, I returned to OMBC the medical release forms it requested, limited to termination of the doctor-patient relationship. OMBC thereafter did not contact me to discuss my complaint or for any other reason until by letter dated November 30th, 2020, OMBC enforcement analyst Robin Matson informed me that regarding my complaint for quality of care, the consultant could not establish sufficient cause to warrant pursuing further action in this case. Ms. Matson included OMBC's phone number to call with questions, so I called on December 8th and left a voice message. My call was never returned. That same day, I mailed an appeal of the OMBC decision based upon clear and unmistakable error, given that my complaint was for patient abandonment, not quality of care, which OMBC now says is the same thing. By January 19th of this year, OMBC had not contacted me, including to confirm receipt of my appeal. I therefore that day emailed to OMBC a digital copy of my December 8th letter of appeal. OMBC did not reply. On July 7th, I emailed OMBC Board President Buhari a copy of my appeal, no reply. So basically, and I was not aware that this was the timing, that would have been helpful to have. Robin Matson, she decided the appeal. She decided not to give me my records when I requested them. So I request that this board make sure that it revises its rules and procedures so that complainants are actually engaging in one actual discussion with the complainant about their case during the investigation and not permit a singular analyst to decide a case, determine the appeal of that decision, and then also decide whether any records will be provided to the complainant. The conflict of interest is unmistakable. Thank you.
Thank you. And just as a reminder, as Dr. Buhari mentioned at the beginning of public comments are limited to 2 minutes. Our next comment comes from Michelle Montserrat Ramos. Michelle, I've sent a request to unmute your microphone.
My name is Michelle Montserrat Ramos. Can you hear me?
We can.
Great. Good morning, board members. My name is Michelle Montserrat Ramos, and I'm with Consumer Watchdog, a consumer rights group based in Los Angeles. I have been advocating with and monitoring the Mega Board of California for the past 16 years. Denise Pines is familiar with me. I'm a former member of the California Department of Public Health, Healthcare Acquired Infection Advisory Committee. I work with advocates across the state of California, educating consumers on medical negligence and helping consumers navigate through your complaint and enforcement process. I just want to introduce myself. It's nice to meet you, and I'm looking forward to your meetings and working with you. Thank you.
Thank you. And at this time, that's the only request we've received. Would you like me to close the panel?
Yes, I think if there are no more public comments requested, then we can close that.
It is closed.
Thank you. And thank you to the members, public members who gave comments. We're going to move on to agenda item 3, review and possible approval of the minutes. Review and possible approval of minutes from May 13th, 2021. Any discussions from the board or board members?
Yes, good morning. This is board member Andrew Moreno. Can you hear me?
Yes, good morning, Andrew.
Yes, just wanted to state my presence. I was here this morning, but I wasn't called on the roll call.
All right, so Machiko, can we make sure that he
So
was?
sorry.
Oh.
I don't know how I missed you, Andrew.
That's okay. Thank you.
You're welcome.
All right, so may I have a motion to approve the minutes for the May 13th meeting?
This is member Moreno again. I'll make a motion to adopt the May 13th board meeting minutes.
Is there a second?
Dr. Jensen, I second the motion.
Thank you. So it has been moved and seconded. Moderator, any public comment requests?
I'd like to abstain from the vote just because I wasn't here at the last meeting. This is Denise Pines. Thank you.
Certainly.
This is the moderator. We've again opened the Q&A panel. If you'd like to make a comment on the motion before you, please click on the Q&A icon on your screen, type comment into the text field and submit that to our panelists, or you may also raise your hand by locating that raise hand icon next to your name. Not seeing any requests for comment. Would you like me to close the panel?
Yes, please.
It is closed, and just so you're aware, member Mercado has joined us.
All right, wonderful. Machiko, will you do the roll call?
I will. Gora Damian.
Present.
Oh, this is for a vote on the motion to approve the minutes.
Aye.
Dr. Buhari.
Yes.
Dr. Jensen.
Yes.
Claudia Mercado.
Yes.
Andrew Marino.
Yes.
Dr. Patel.
Yes.
We have voted to approve.
Okay. So the motion is carried. We're going to go ahead and move on to agenda item number 4, the petition for modification of probation. The purpose of the hearings today is for the board to consider a petition for modification of probation. This proceeding is a serious matter and proper decorum must be maintained. Please make sure that you keep as quiet as possible during the hearings and that you refrain from making comments or expressions that may disrupt the hearings. Your cooperation in keeping these proceedings orderly is appreciated. And I'm going to turn this over to our administrative law judge at this point.
Good afternoon, board members and president. Do we have the court reporter?
Yes, Your Honor, I'm here.
Okay, and if I could have your name, please?
Marie Milgren?
Mellgren?
Correct, Your Honor.
And if I could have your court reporter number?
Yes, it is 9442.
Thank you. And if you could remain on after the conclusion of the petition for the number of pages.
I will. Thank you, Your Honor.
Thank you so much. Do we have counsel for the Attorney General's office?
Yes, Judge Brown, I'm here. Can you see and hear me?
Yes, I can.
Would you like me to state my appearance for the record at this time?
Well, we're not on the record yet.
Oh, okay.
Do we have counsel for the petitioner? Dr. Paget, are you on the line?
I am, Your Honor. My counsel is here, but he can't get in. He's not been invited in yet.
Okay, his name is Mr. Peachy, P-I-C-C-H-I. If you could raise your hand so that you may be allowed in.
This is the moderator. I have promoted him.
Oh, thank you. Mr. Peachy? Can you unmute yourself?
Mr. Peachy, this is the moderator. You should see a mute and unmute button on your screen. If you could click that, it should unmute your microphone.
There you are. Sorry, I could not find my name. I apologize. Thank you. Can you
That's
hear me?
okay, and we can. And you should also see a start video button on your screen. If you could click that, that will activate your camera.
There we go. That should be it. Okay, thank you.
Okay,
Welcome.
thank you. So President Buhari, I think we are ready to proceed. Can we go on the record now, Madam Court Reporter?
Your Honor.
All right. We are on the record before the Osteopathic Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the petition for modification of probation by David K. Paget, P-A-D-G-E-T-T-D-O, petitioner. Case number, this is the board's case number 900-201-0000071. This is OAH case number 2021-08-0706. Today's date is September 23rd, 2021. The time is 10:18 a.m. This hearing is being held remotely through WebEx. My name is Regina Brown. I am an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over this matter. Counsel, if you could please state your appearances for the record, starting with counsel for the Attorney General.
Yes, good morning. My name is Hamsa, H-A-M-S-A, Murthy, M-U-R-T-H-Y. I'm Deputy Attorney General, and I am appearing today in this matter on behalf of the Office of the Attorney General of California and the people of the state.
Thank you. Counsel for petitioner?
Yes, good morning. My name is Joseph S. Peakey. I am counsel for the respondent, David Keith Paget, D.O.
Thank you. So I will just make a few preliminary remarks. The Deputy Attorney General will first offer the jurisdictional documents that were submitted in support of the petition, which have been uploaded into our case lines documentation, into case lines. After the petitioner has been heard, the board will meet in closed session for deliberations. The board's decision will not be announced today. It will be announced, a written decision will be mailed out to the parties as soon as possible. We do have a court reporter taking down all of the testimony on the record. The court reporter can only take down one person speaking at a time. So it's important that we not speak over each other and that you identify yourself before speaking initially. At some points during the hearing, the court reporter may need to interrupt to ensure that we have a clear and complete record. Please make sure that you and any witnesses are in closed, quiet rooms with no excessive paper rustling or talking to other people during the course of the proceedings. After the petitioner has testified and been under cross-examination, I will then ask each board member if they have any additional questions. So with that, Ms. Murthy, if you would proceed with offering the documents into evidence.
Yes, thank you, Your Honor. And I just wanted to state also for the record that it's my understanding that the board members do not have access to case lines. However, the PDF packet that was made in this case corresponds exactly with the page numbers in case lines. So we should be good. The AG number and the case lines numbers are the same.
Thank you.
So with that, Your Honor, I'd like to offer Exhibit 1, which is a notice of today's hearing into evidence.
Any objection?
No objection, Your Honor.
Exhibit 1 is in evidence.
I'd like to now offer Exhibit 2, which is a certificate of the licensure of Dr. Paget.
Any objection?
No objection, Your Honor.
Exhibit 2 is in evidence.
I'd like to now offer Exhibit 3, which is the petition for modification packet submitted by Dr. Paget.
Any objection?
No objection, Your Honor.
Exhibit 3 is in evidence.
I'd now like to offer Exhibit 4, which are clinical assessment reports received by the board in this over the course of probation in this matter.
Any objection?
No objections.
Exhibit 4 is in evidence.
I'd now like to offer, please, Exhibit 5, which are quarterly monitoring probation reports received by the board.
Any objection?
No objection, Your Honor.
Exhibit 5 is in evidence.
I'd now like to offer Exhibit 6, which are certificates of completion of coursework done by Dr. Paget.
Any objection?
No objection, Your Honor.
Exhibit 6 is in evidence.
And I'd like to also offer Exhibit 7, which is a cost recovery detail and accounting report.
Any objection?
No objection.
Exhibit 7 is in evidence.
And Your Honor, one more additional thing under additional documents, just for reference, I have included an index of the exhibits that was part of the original PDF packet for folks' convenience.
Thank you. Anything else?
No, Your Honor.
All right. So, Mr. Peachy, would you like me to swear in your client?
Yes.
Dr. Paget, if I could have you raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the evidence that you shall give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
And if you could please state and spell your name for the record.
David Keith Paget, P-A-D-G-E-T-T.
Thank you. You may proceed, Mr. Peachy.
Okay, Dr. Paget, you prepared a statement with respect to your rehabilitation since the commencement of commencement of your probation. Is that correct?
Yes, sir.
First of all, have you complied with all the terms and conditions thus far of your probation?
Yes, I have.
And that includes the coursework that you were asked to complete, correct?
Correct.
And your practice has been monitored by another physician?
Yes, it has.
And quarterly reports have been duly submitted showing your compliance?
Yes, sir.
And those are all part of the exhibit package that we have submitted today and have been entered into evidence?
Yes, it is. Yes, they are.
So with that in mind, I'd like you to, and you've also, I know that the one area that you have had that you have not yet completed successfully is the monetary repayment of the monetary costs for the underlying litigation that was pursued against you as part of the disciplinary action. Is that correct?
That's correct.
All right. Can you tell us what you have paid and how you have paid that?
I paid $17,000 at $500 per month starting in December of 2018.
Okay. And why is it that you have not been able to complete payment of the approximately $66,000? Is that what is owed?
Yes.
Can you tell the board why that's been an issue for you?
It's been a financial hardship for me due to income loss since probation.
All right. Can you explain why that is the case?
The first year and a half of probation, I had to pay for courses, the practice assessment, legal fees that were quite a bit outside of what my insurance covered, and just cost of keeping my office going and my HR and the cost of living in the Bay Area. It's beyond my capacity to pay more than $500 per month. My income has dropped 80% from where it was before probation begins.
Okay. So, and essentially you have been paying how much a month?
$500.
And have you dutifully done that since the beginning of your probation to the present time?
I started in December 2018.
All right. And have you experienced financial hardship as a result of the discipline that that was provided to you or given to you?
Significant.
Okay. Can you describe that for us, please?
I'm in the negative every month. We've been using retirement funds to pay just living expenses now for several years.
All right. I take it that I know that part of the request that you've made in the petition that you personally submitted to the board is that the fine be either reduced or be deemed to have been satisfied. Is that true?
Yes, sir.
Tell me why you think that that is indicated in this case.
I've taken the probation to heart, and my understanding is that the reason for probation is to rehabilitate the physician who's violated the standard of care and has learned from what he's done. And I believe I have fully learned my errors and am practicing in a different way than I was prior to the accusation being filed. So I believe I fulfilled what has been required of me, with the exception of the financial payback. And I just financially it's a great hardship for me to do that.
Now you say that you have learned from your mistakes of the past, which served as the basis for discipline of you in this matter, correct?
Yes, sir.
All right. Can you explain to the board what it is that you have? The board wants to know why it is that if they were to commute your sentence, why they would be satisfied that you would not be a risk to, and that you would practice safely. And can you tell us why that would be the case?
I haven't. I have determined, as a pain management practitioner, I had stopped taking new medication management patients into my practice, I believe, as of 2015. And I started weaning or eliminating all of my patients who were on Schedule 2 and 3 opiates in 2016. And by April of 2017, I believe all of my patients were off of all Schedule 2s and 3s. And I have no intention of going back to that practice. I'm still doing pain management. I still work in 2 pain management group practices as a consultant. I have my own practice, and I would like to stay as a solo practitioner using my osteopathic manipulative skills, treating musculoskeletal pain, as well as the catastrophic patients that I also see as a physiatrist, those brain injured and spinal cord injured patients that are referred to me. I do not want to go back to doing medication management practice, which was a significant percentage of my practice prior to the accusation and probation.
From this incident, Doctor, I want to ask you, what have you learned from this, and how have you integrated into your practice?
I have recognized that I've had a hard time following my own office policies and procedures, and My records were bad. I did not dot the I's and cross the T's. And although I believe that I followed all the guidelines, it wasn't documented. And if it wasn't documented, then it didn't happen from an outside view. I now document everything to the nth degree. And I follow all the guidelines for the few people I have left on tramadol. All the guidelines for prescribing opiates for pain are followed exactly in my office, if not more than the guideline recommendation.
Go ahead, keep going. Is there something else you want to say?
Well, I recognize my own personal weaknesses, which is I tend to believe my patients and want to believe them, and I realize that I don't want to put myself in a position again where I'm having to decide about prescribing a medication for someone who may not be truthful with me. I just don't want to put myself in that environment again.
So how do you plan on preventing that from happening in the future?
I'm not going to be prescribing Schedule 2s and 3s. And then once I believe I have 10 remaining tramadol patients in my personal practice. And once they're all out of my practice, once they matriculate out for whatever reason, they move or they settle their workers' comp case and no longer see me, they're going to their private doctor or what have you. I'm planning on not prescribing any further tramadol. And again, I have not written a new prescription for an opiate for someone who was not already on it since 2016.
Earlier, you indicated that you want to avoid getting yourself in a situation where you're somewhat manipulated by patients or that you are unsuspectingly entrusting them more than you should. How do you plan on, what assurances does the board have that if left to practice unmonitored, that you would be able to control that facet of your practice?
Again, I made the decision before I was placed on probation to no longer practice that side of what I was doing, medication management. So since 2015, I've not taken on any new patient. I am fully committed that I will not prescribe again in my private practice. If I am fortunate enough to be able to get a hospital position again, where I'm taking care of rehabilitation patients who've had catastrophic injuries and who need to be on opiates for neuropathic pain or for whatever reason, I will follow the strict guidelines that are out there and plan to, or do even more, and plan to make sure that any prescription that I'm having to write as an attending physician is for no more than 3 to 5 days of opiates, and make sure the patients are seen by their surgeon or whoever's taking over in an outpatient setting. I know each state is different. I don't know whether California is 7 days or 3 days because I haven't been in the hospital setting in a while, but I would certainly know if I'm able to go back in the hospital work.
Now you've had your case, you've had practice monitored over the course of your probation, right?
Correct.
And tell us about, have you been in compliance at all times with when those persons have come to inspect your practice and look at your records? Have you, in all respects, been compliant with what they were expecting you to do and compliant with the standard of care?
Yes.
All right. Was there, and so what have you learned from, have you learned anything from having these monitors come and look at your records and look at your practice?
Well, it was pretty humbling and embarrassing, I must say, but you know, they gave me recommendations of how to have my records more clearly organized. The basic recommendation they thought would, my practice monitor, Dr. Roberts, thought would make things easier for my records to be viewed would be establishment of an EMR in the practice. I considered that quite a bit. I use an EMR in the 2 group practices I work in, but in my private practice, quite honestly, my finances don't allow me to afford the capital expense for buying equipment and hiring new staff. My staff has dropped by 2/3 from what it was before my probation. So, so other than an EMR, he's been satisfied with how I've been organizing my records and now explaining very clearly what my treatment plan is for patients.
You have a probation monitor as well?
Well, I had a supervisor, which was Dr. Roberts. So initially I was seeing him every 2 weeks. And it's been allowed to be dropped down to every month. Mr. Forey Sparks is my Osteopathic Medical Board monitor, probation monitor.
Okay, and you have been dutifully reporting to Mr. Sparks throughout your probation?
Yes, I had one quarterly report that I was 7 days late on because an error in my head. I just forgot the days. But other than one time, everything has been on time.
Has Mr. Sparks given you feedback about your progress over the course of your probation?
Yes, he has. And I don't want to put words in Mr. Sparks's head because he's on this call, but he's told me that I've done everything as expected. My courses were done actually in advance of deadline, and I've been upfront and told him everything that's going on. We've been in communication a lot over these past 4 years.
You have, as part of the materials that you submitted to the board for their consideration, you have letters from 3 physicians who are your peers. Is that true?
Correct.
Can you tell us who they are and why you asked them to issue these statements on your behalf?
Well, the first letter was from Dr. John Roberts, who is my practice supervisor. And I asked him to basically give us a brief statement that I have been in compliance. The other 2 letters were from other pain management physiatrists, one from each of the 2 pain management groups that I have been working with for several years.
Okay, so all these people are familiar with your practice presently and what you've been going through in terms since your probation up to the present time, right?
Yes, they are.
Okay, and these are persons who are well familiar with the way you practice.
Yes, they are. I do EMGs every week for IPM. That's Dr. Weil, and I see patients 2 days a week for Rehab 1 Medical Group, and that's Dr. Fujimoto, and who both of them co-signed my reports.
Now,
excuse me, hold on.
Sure.
Can we get a spelling for the court reporter of the names?
Yes, ma'am. IPM Medical Group is Lawrence Weil, W-I-E-L, M-D. And Rehab 1 Medical Group is Ronald Fujimoto, F-U-J-I-M-O-T-O,
You completed all the coursework you were asked to do that as part of the findings by the judge and the order of the board?
Yes.
Okay, and you completed that prior to your actually the time when it was due. Is that true?
That's correct.
And let's see. And those are the certificates that you've provided those certificates of your completion as part of the materials that you submitted to the board in your petition for commutation of your sentence, right?
Yes, sir.
So what have you learned from this experience?
I've learned a lot. I have a statement if that goes over everything. If you'd like me to read it, otherwise I can explain it as best I can, and as nervous as I am.
Your Honor, do you have a problem with him reading a statement?
If he's going to, I would prefer he not read it if it's in the exhibits, because I believe that all of the members can read it for themselves. He could probably give us the highlights. In addition, when you read fast. So if you read anything, you're going to have to read very slowly for this court reporter. Thank you.
Yes, ma'am. It's a different statement than I submitted in my packet in June.
Okay, so read it slowly.
Okay. All right. So again, I want to thank everyone for allowing me this opportunity, Your Honor, members of the OMBC and the Deputy Attorney General. I want to stress to you that I've taken my probation very seriously and have done everything required. I've taken to heart what I've learned in my mandated classes, and I now understand what errors I made in my practice.
Now that's a bit too fast.
Okay, sorry, Your Honor.
Our court reporter can't type that. She can type really fast, but you're going to have to slow down.
Yes, ma'am. I believe I'm rehabilitated, and I intend to practice in a much safer fashion than I did before my probation. I'm presenting this narrative because I recognize how busy you all are and that you may not have been able to review my packet. So I want to let you know why I'm petitioning for penalty relief. My probation started in June of 2017. I've been on probation for more than 4 years of a 7-year term of probation. Judge Schlickman found me guilty of, quote, being negligent in providing care or providing large doses of opioid medication to these patients without conducting an appropriate examination, obtaining informed consent, determining a medical indication for the treatment, adequately documenting his treatment, identifying a treatment plan, and conducting a periodic reviews of the treatment plan, end quote. Judge Schlickman further commented in her decision that she was troubled that I failed to recognize my errors, stating, quote, it is very troubling that respondent does not consider himself to have violated the standard of care in the treatment of these 3 patients in any respect, end quote. I have reflected greatly on the accusation and court decision. I admit, initially I was quite bitter and angry towards the court and this board as I felt the decision was unjust. I viewed myself as a good doctor and perhaps even a great rehabilitation pain specialist. I trusted the medical literature that was present from the early and mid 2000s and through, frankly, as late as 2015, that high dose opiates were appropriate and beneficial in a certain very small percent of patients. The medical literature has now substantially changed. Through the course of my probation and my mandated coursework, I have come to realize that not only did I place myself in this position to be disciplined, but I placed my patients in jeopardy through my actions. And as a result, the OMBC had every right and requirement to follow their mandate as spelled out in the Osteopathic Act to protect the public and place me on probation. Prior to probation, I never recall having read the Medical Board of California's guidelines for prescribing controlled substances for pain. I never recall having read the Federation of States Medical Boards model policy on the use of opioid analgesics in the treatment of chronic pain. I thought I was practicing above reproach, frankly. As homework in my mandated classes, I had to read those documents. Further, I had to critically review my practice behavior. I found myself changing from anger and incredulity to sorrow and embarrassment over my errors. I came to realize that my personal and professional behavior and yes, arrogance allowed me to not see appropriate changes that had been coming since at least 1999, about rising addiction rates and changing tides in pain medicine prescribing, particularly of opioids and ill-advised use of certain classes of medication with opioids. I was careless, and in some regards, I was reckless. I also realized through reading my accusation and then through my mandated class on medical records that I had taken too many shortcuts in my charting. It caused me to miss critical issues of concern for possible abuse and addiction in my patients. I did not follow the safeguards that I had established to prevent abuse, for example, not allowing early refills. I did not maintain a record that could be easily understood by anyone else. I did not institute the clearly well-described monitoring and documentation steps that the guidelines recommended. I certainly was not consistently adhering to any of the guidelines or even to my own office policies and procedures. And as a result, I'm here today with a shadow of the practice that I had before. I can blame no one or no thing but myself for this predicament. My probation has forced me to reflect on my continued pain management practice. My investigation, accusation, and eventual probation also afforded me the ability to educate my fellow pain management physicians in what errors I made and how they could change their practices to avoid making the same errors I did. Prior to my hearing in front of Judge Schlickman, I had already begun the process of changing my practice. I had stopped accepting new pain medication management patients and had been reducing dosages of prescribed opiates to existing patients, plus transferring patients to other pain practices. I had also initiated routine drug screening in my office and checking cures, something I previously mostly did when I thought I was smart enough to see red flags in my patients. I was wrong. However, I was changing too slowly. During the first year of my probation, while I was consulting with 2 pain management group practices, I observed the team of support staff needed to remain in compliance. Further, I was able to observe the behaviors exhibited by patients as my colleagues steadily reduced scheduled medications to achieve compliance with the CDC guidelines. I realized that I had missed a lot of concerning patient behaviors that I should have noticed throughout my practice. I considered adding an addiction medicine specialty to fill in my knowledge gaps. I took a course in addiction medicine and did a great deal of reading on the topic. However, after much consideration, I ultimately decided I wanted to make a significant practice change away from medication management of chronic pain and to instead develop and expand 2 areas of my practice that always had been there, osteopathic manual medicine, OMT, to address structural pain issues, and outpatient rehabilitation of catastrophic injury patients. Both of these areas had always been a small but rewarding part of my practice, as was my larger practice of inpatient rehabilitation and medical administration. I will continue to care for benign chronic pain patients. However, I recognize that a solo practice utilizing opiates would be very challenged to follow appropriate safeguards and monitoring needed to be in compliance with the guidelines for prescribing controlled substances for pain that would ensure the safety of its patients. I no longer prescribe Schedule II and Schedule III medications and intend not to do so again. I still have a small number of chronic pain patients on Schedule IV opiate and tramadol, as I said. They've all been on that medication for years. I think I have 10. I routinely check cures with every refill prescription, obtain toxicology screens every 3 to 6 months. All patients have a medication contract. I inquire about the 5 A's with every refill. Every patient has been given informed consent that is written to be on tramadol. None of these patients is concurrently on a benzodiazepine, soma, or hypnotic sleeper. And as these patients eventually matriculate out of my practice, I plan to no longer prescribe even tramadol. So what is my request? I'm asking for a modification of the terms of my probation, both duration of probation and in cost recovery. I completed all the training and assessments required by the board in my first year of probation, ahead of schedule, and continue to meet all the ongoing probation requirements. I have been paying $500 per month, as I said, towards cost recovery since the end of 2018. I was unable to begin payback earlier because of the cost of paying for the board-ordered classes.
Dr. Paget,
Ma'am?
you are repeating most of your testimony now, so I need you to wrap it up.
Bring it home, Dr. Paget.
I just wanted to say that what I've not said is that for years, a majority of my income, more than 50%, derived from my inpatient practice and my medical director stipends. After the accusation was filed, I was stripped of medical directorship, lost all of my hospital income, and with probation, I lost most of my income, my insurance plans. The losses, when added up, are staggering. The ramifications of this probation have been hard-hitting, eye-opening, embarrassing, and humbling. And this experience has been full of learning and self-evaluation. So I just want to finish by saying that I've never wanted to leave the profession of osteopathic medicine. While this has been a tremendous hardship to myself and my family, I love being able to help my patients and feel that today I'm better able to do so than any time in my career. And in addition, with what I've learned, I believe I can be a good example for other doctors who continue to treat patients in pain. So I thank you for hearing my petition, and I'll answer any other questions that there are. Thank you.
That's all we have, Your Honor.
All right, Ms. Murphy, cross-examination?
Yes, Your Honor. Thank you. Good morning, Dr. Paget, and thank you for being here. I wonder, sir, if I could ask you to please expand a bit on a statement that you make in your letter, which is in the record at page 56. And in that statement, you say that you now better understand addiction. Could you expand on that, please?
And just for the record, page 56 is in Exhibit 3.
Thank you.
I had not, although I had read articles about addiction, addiction was never part of my training before the accusation and probation. There were always talks on it in CME courses, but it was never really a part, and it's a separate specialty. I tried for some patients, including one of the patients that I'm on probation for, getting the patient to an addictionologist to be part of my treatment team. It was a workers' comp patient, and I had lots of resistance to that. But after taking the classes and reading the guidelines, I realized I missed a bunch of stuff. And there are a few pain management practitioners out there who I interact with in groups I'm members of, who have dual certification. And so I started doing reading and realized, wow, I missed a lot of behaviors that I should have recognized. And I fell for a lot of stuff patients told me. That's on me. That's not on them. That's on me. So I did a lot of reading. I took the American Osteopathic College of Addiction Medicine's board review course, thinking I would like to take the board exam and change my mind and decide that, I just don't want to be involved in managing patients on the level of medications that would come to me as an addictionologist, or even as a chronic pain patient managing high-dose opiate medications.
Thank you. And I'd like to ask you now, sir, in your petition for probation modification, which appears at page 7, the form, which is in Exhibit 3, you also state that one of the things that you are requesting is that the no solo practice prohibition be lifted. That's correct. Is that correct? Yeah. So on that topic, I would just like for you to explain your plans related to being a solo practitioner going forward. Is it fair to say that if that particular condition is changed, you plan to be a solo practitioner full time?
Currently, I am a single person office 2 days a week. And then I meet with my practice supervisor, Dr. Roberts, who has this office a couple buildings over from me on a regular basis. The other 3 days a week, I actually, since the start of the pandemic, March of 2020, I've been working remote with Rehab One Medical Group, which is based in the South Bay, seeing patients remotely. And then 1 day a week, I do EMGs for the other pain management group, IPM. I don't see that changing right now. I've been trying to increase my volume in my personal practice for the whole time I've been on probation, and I'm seeing about 33 patients a week in my solo practice, and that number has remained about the same. The patients I'm getting now to my practice are catastrophic injury patients, because I'm a physiatrist, I'm a physical medicine and rehab specialist, and I'm one of only a few doctors in the Bay Area that sees these catastrophic injured patients after they're released from the hospital and manages them. And mostly those are brain injury and spinal cord injury patients. There's some polytrauma patients where the orthopedic surgeons don't want to follow them in their workers' comp. So I have some workers' comp case managers that send patients to me. None of those patients are on opiates. I don't accept any new patients who are on opiates. So when the referrals come in, my staff knows to screen them out, and I don't accept any of them. The other patients that come in are people who find me on the internet as an osteopath and who are looking for a manual medicine practitioner to treat them. And so those are the two areas that the vast majority of patients are of those two categories. I have a few of my own workers' comp patients that have been with me long term, and they're pain management patients.
So it's fair to say that that going forward, you would like to expand this aspect of your solo practice that you've discussed with us today, correct?
I would like to, if possible.
And is it also fair to say that you'd like to put yourself forward for hospital positions again, if going forward? Is that fair?
Yes, ma'am.
And your plan is, as I understand it, to also continue to work with the group practices that you've been working with during the course of the probation. Is that correct?
Yes, ma'am.
If I could ask you, sir, to expand. We've heard a little bit about the substantive knowledge you've really delved into and gained with respect to prescribing, and we've also heard about some of the work that you've done and thinking you've done in terms of medical records. But I wondered if you could please tell us what you learned from the medical ethics course, a certificate which appears in Exhibit 6 at page 325, which I believe you took in October of 2017.
So that was a very interesting course, because I thought that, why am I taking an ethics course? I'm an ethical guy. I don't sell anything from my office. I tried throughout my practice to help patients be more functional and minimize as much pain medication as possible. But I learned that my lack of recognizing abuse potential was a violation in ethical standards. My failure to recognize that I wasn't keeping up with the standard of care in my medical records could be viewed as an ethical deviation. I didn't do it. Most people think of ethics as inappropriate touching or comments but I learned that ethics is much more than that. It's practicing within community norms, the greater community. And I thought I was doing that, but I recognized that I was not. I was in my own little head as to what I thought was right and wrong. Hopefully I've answered your question.
Yes, thank you very much. And Your Honor, I have no further questions.
Thank you. Mr. Peachy, do you have anything in redirect?
I don't, Your Honor. Thank you.
I'd like to ask each member if they have questions, starting with President Buhari. Any questions?
I have no questions at this time.
Thank you. Vice President Jensen,
No, ma'am, I do not.
Secretary Moreno,
No, Your Honor, no questions at this time.
Mr. Adamian, and I'm sorry if I mispronounced your name.
No questions.
Ms. Mikado,
No questions at this time, thank you.
Dr. Patel,
I have no questions, Your Honor.
and Ms. Pines.
I have no questions either.
Thank you. Would you like to make a closing argument, Mr. Peachy?
Well, I'd just like to add, Your Honor, and I'll be very brief, that I think my client has demonstrated that he's been completely compliant with all the requirements of his probation, including with the exception of having not paid off the monetary costs that he was saddled with at the time of the sentencing, and he has demonstrated that he has taken to heart the discipline that was provided to him by the medical board, and also he has taken to heart the importance of compliance with all the requirements that were of subject of his probation. He understands that part of that is paying back the cost, but essentially I think he's made a strong point due to and I think we all realize who work in this industry that the sentencing, these kinds of punishment are far beyond. They go far beyond what the actual punishment is by the board, because in the marketplace, the financial impact that they have on the practitioner are devastating, as is the case here, which makes it very difficult to maintain a living and also pay off substantial costs. So while he hasn't been able to pay off all those costs, I'm hoping that the board can either modify that, because it is quite extensive, and that's one thing that he's asked for specifically. And the other is that I think he's demonstrated that he's learned his lesson, that he will practice safely. He's given assurances of that. He's demonstrated a strong understanding of the practice guidelines and their importance in practicing safely. He's recognized, and I think this was one of the concerns of Judge Schlickman, was that he didn't see the errors in his way, but he has put himself before the board and acknowledged that he had made mistakes and that he now realizes and recognizes those. So I think that looking at this man, he has demonstrated that he can practice safely, that he's a credit to the profession. He should be allowed. There should be some. The sentence he got was 7 years probation, and that was in excess of what the Attorney General was asking. So I think that he has demonstrated he's taken it all to heart, and I'm hoping that the board can see all that and find it in itself to shorten his term.
Thank you.
That's it. Thank you.
Thank you. Any closing remarks, Ms. Murthy?
Just very, very briefly, Your Honor, I also wanted to acknowledge that complainant at the original hearing in 2017, as evidenced on page 48 of the record, requested a minimum of 5 years probation in this case. 5 years of probation will be completed by Dr. Padgett in June of 2022. And with what we have seen in the record and heard here, I would say that the Attorney General's office and on behalf of the people of the state of California, we do not oppose this petition for modification of the terms of probation. Thank you.
Thank you. Madam Court Reporter, the spelling for Schlickman is Schlichtmann. Did you need any other spellings?
No, Your Honor.
Thank you. So as I indicated earlier, the board will deliberate in closed session and a written decision will be mailed to the parties. At this time, this matter is submitted and we are off the record, and I will return it back to the president of the board.
Thank you,
Thank you,
Madam
Judge.
You're welcome.
The meeting will now adjourn to closed session for the purposes of hearing deliberations and disciplinary actions. After the conclusion of the closed session, the meeting will return to open session. All right, we'll call the meeting back into order. And we are on agenda number 5, the Department of Consumer Affairs update. Mark, is the DCA prepared to do their update at this point? Go ahead, Mark. There he is.
Dr. Bahari, I believe the Department of Consumer Affairs is in this meeting and ready to do their presentation.
Okay, so we can move forward with agenda item number 5.
Hello, this is Brianna Miller. Can everyone hear me all right?
Yes.
Wonderful, thank you. Well, good afternoon, board president and board members. As I said, I'm Brianna Miller with the Department of Consumer Affairs, and I'm with the DCA Board and Bureau Relations. Thank you for allowing me the opportunity to provide a department update today. And before I get started, I would like to take the opportunity to also welcome Member Pines to the board. Welcome, Member Pines, and thank you for your service. One of our top priorities in Board and Bureau Relations is appointments, and I would like to provide a brief overview. Currently, the board has 2 vacancies, both licensee seats, appointed by the governor. DCA and all the appointing authorities share the goal of a fully seated, diverse, and effective board. Filling current and upcoming vacancies is a priority. If any members know any great candidates, or if any members of the public are interested in serving, please find the link titled Board Member Resources on DCA's homepage to apply for an appointment. And I'd next like to discuss remote meetings. DCA is receiving many questions about when and how boards will meet again in person and whether they can also continue to meet. On September 16th, Governor Newsom signed legislation that will extend the ability of boards and committees to meet remotely by amending the Bagley-Keene Open Meetings Act. Though in-person meetings are also allowable by law, DCA encourages its boards and bureaus to continue utilizing remote meetings to protect the health of staff, board and committee members, and the public. Should your board desire to hold an in-person meeting, please communicate those plans to DCA as soon as possible so DCA can assist with coordination of teleconference options for the public, vaccination verification, and COVID-19 testing. Moving on to those COVID-19 safety measures. To combat the spread of COVID-19 and protect vulnerable communities, California is implementing enhanced safety measures for state employees and workers in healthcare settings. State employees must show proof of vaccination or they will be subject to regular COVID-19 testing and will be required to wear appropriate PPE. Board and committee members are considered employees and must follow health and safety protocols if they plan to visit a DCA location or attend an in-person board meeting. Members must verify vaccination or follow face covering and testing protocols in accordance with that location's requirements. DCA's testing program is expected to roll out at the end of this month, and you will receive details and instructions accordingly. And as it pertains to healthcare settings, to further protect Californians and the healthcare workers, the California Department of Public Health recently issued 2 public health orders. The first order requires workers in healthcare settings to be fully vaccinated or receive their second dose by September 30th, 2021. The second public health order directs hospitals, skilled nursing facilities, and intermediate care facilities to verify that visitors are fully vaccinated or have tested negative for COVID-19 in the prior 72 hours before indoor visits. Licensees are encouraged to thoroughly read the CDPH public health orders and regularly check their local public health department's websites for additional vaccination requirements. Questions from licensees about the healthcare worker requirements should be directed to the California Department of Public Health. And we know things are moving quickly and there's a lot of information, both official and unofficial. Statewide guidance for the use of face coverings from the California Department of Public Health remains in place unless a local health jurisdiction issues a stricter public health ordinance tailored for the situation in their communities. Many counties have revised health orders requiring face masks to be worn by both vaccinated and unvaccinated individuals while indoors. I encourage all members and the public to visit DCA's COVID-19 webpage for updates and resources on the state's reopening plan, public health guidance, vaccinated resources, vaccine distribution, and more. And finally, I'd like to provide a reminder about the board member trainings and learning management system. As a reminder, 2021 is a mandatory sexual harassment prevention training year. So this means that all employees and board members are required to complete the training during this year. Please also be advised that you will now access this training through the Learning Management System, or LMS for short, which is DCA's training portal. We have created profiles for each of you in the LMS and informed your executive officer of the steps you will need to take to log in and access the training. Board and Bureau Relations is also happy to assist you with any questions or concerns you have about using LMS. Ultimately, the LMS will house your training records and may also be used to sign up for other mandatory trainings. And I'm pleased to announce that you can now register for the board member orientation training via the LMS. So as a reminder, newly appointed and reappointed board members are required to attend the board member orientation training within a year of appointment and reappointment. The final training of 2021 will be held via WebEx on October 13th, and I'm happy to assist in any members who are interested in attending the training. I'm happy to assist in your registration. So as always, Board and Bureau Relations is here to help, and if there's anything we can do to assist you and your board, please reach out to us. So that concludes my presentation. I will hand it back over to Board President Buhari. Thank you.
Thank you very much. All right. Any discussion from the board members? Seeing no additional discussion, we will now entertain comments from the public. Moderator, is there any member of the public who wishes to have comment?
This is the moderator. We've opened the Q&A panel. Again, if you'd like to comment on this presentation, please click on the Q&A icon on your screen, type comment into the text field, and submit that to all panelists. You may also utilize the hand raise feature by locating the hand icon next to your name. And not seeing any requests, would you like me to close the panel?
Yes, please.
It is closed.
All right, thank you. And we'll move on to agenda item number 6, the budget update. Mark Ito.
Thank you, Dr. Buhari, and good afternoon, board members. I'm excited to present the budget update today. So DCA participates in incremental budgeting. That's how we build our budget every year, which means we don't start from zero. We start where we left off from last year, and from there we make incremental changes to the budget through mechanisms such as budget change proposals and budget drills, such as employee compensation, retirements, adjustments, and things of that nature. And then we build our budget from there. So the board's budget for this year is $3.025 million. That's our budget appropriation and what we are allocated to spend every year. And also the way we do our budgeting is we do bottom line budgeting. We have dollars associated and allocated for every expenditure line item. But at the end of the day, as long as we are spending within our total budget, then we will have a budget savings at that point. So for last fiscal year, our projected expenditures were are $2.755 million, and that will that equals a savings of $269,000 in our savings, which equates to about an 8.9% reversion, which is very healthy. You know, our budget's healthy. We don't really have any concerns over our spending. Now going to the chart in front of you, I know there's a lot of numbers there. I'll kind of briefly go over how that chart works. So on the very left, it has all of the expenditure line items. The top portion of that is the personal services, which is staff, staff salaries, per diem, overtime, staff benefits. So that's all captured in that top section. And then below is operation expenses and equipment, also known as OE&E, and that is all the other type of expenses we have that can range from office supplies to AG costs, OAH costs, all enforcement costs are down there. Rata's in there as well, and that's the bottom section. And then in that chart, if you go left to right, the furthest to the left is our prior year expenditures, and as you go farther to the right, it kind of has our budget and then has all our expenditures moving forward. And like I said, we saved $269,000 last year. It's an 8.9% savings rate percentage, and we don't really have any issues with that at all. So our spending is looking good moving forward, and I have zero concerns from that standpoint. So moving on to the next form it's the fund condition. So in layman's term, board fund condition is more or less our bank account. And there's three sections moving from the top to the bottom in that fund condition. There's the beginning balance. That's the amount we start off with every year. And then moving down is our revenue, transfers, and other adjustments. That's how much money that we're bringing into the board. And if you keep going down, it's our expenditures section, which shows our spending every year. And then there's some direct draws from the account, such as statewide pro rata, which pays for, among other things, our control agencies, agency finance, and other things that are direct draws from our account. And then moving left to right, it starts out with our with prior year, which is still preliminary at this point, and then it goes to our current year, and then the last two for 2022, 23. And 23, 24, those are projections for the out years. So an easy way to look at this is if you start with your beginning balance, you add your revenue and it transfers, and you subtract your expenditures, you get your fund balance, which is at the bottom there. And then below that is months in reserve. And kind of an easy way to look at the months in reserve is if the board stopped collecting any money at this point, those months in reserve are how many months the boards can sustain their current operations before we become insolvent and have no money at all. So if you kind of look at this here, if you look at the 2021 year, we brought in about $2.78 million, and we ended up spending about $2.77 million. That means if we look at last year, we were structurally balanced, meaning that we brought in the same revenue and expenditures. That's a good place to be at, and something that the board's proud of. And then if you look at our out years, because the out years for current year and budget year plus one for the out years, those revenues are kind of what we conservatively project to bring in. We typically bring in more than that. Because if you can look at, we project we're going to bring in about $2.8 million. Then if you look at the expenditures down below, it looks like we're going to be spending more than we're bringing in. If you look down at the expenditures section, however, for the current year and the out years, those aren't our actual numbers. We actually have a considerable amount of savings every year. So I anticipate that we are going to be structurally balanced and that we bring in more revenue than we project and we spend more than our actual budget appropriation. So although those months in reserve appear to be going down in this fund condition, in reality, I think it's going to be pretty much straight across. We're 16.8 months in reserve now. We're going to kind of stay along those lines moving forward. So with that said, that is that's my budget presentation. As I said, I have no concern with our expenditures or how our fund looks. And I can proudly say that we function as a board without having any limitations based on our spending.
Question. Mr. Ida, if I remember correctly, we're aiming for at least 12 months, 12 to 14 months in reserve to be our ideal. Is that still a general goal, or is there a minimum that we
Well,
would not want to drop below?
the minimum we don't want to get below is once we get to that 3 to 6 month kind of area, we want to look into maybe looking into a fee increase. And there's also a law that says we can't be over 24 months. And if we are, then we'll have to look into doing a fee decrease. But I think where we are now, where we're spending as much as we're bringing in, I think we're going to be floating around that 12 to 16 months in reserve. So I think we're looking for the time being.
Thank you.
Ms. Pines had a comment?
Is there do we have a statute that says like the lowest we can be in reserves?
I don't believe there's I'll have to look into it. I don't think there's a statute that mentions the lowest we can be. I can look into that. I do know there's a statute that says we shouldn't be over 24 months. But I'll look into that and get back to you.
A question about
Yeah.
the revenues and the projections for 2022, 2023, 24, and that the renewal fees are the same in each bucket. Is there a reason why we didn't apply like a particular growth percentage there than just putting the same number?
So yeah, so I'm actually working with the budget office now, and I did include that growth percentage in our revenue projections moving forward. This fund condition is based on projections that we submitted last year. So I did include those, and I actually submitted that to the budget office yesterday. So I did include that growth in there because we are a growing profession, and our fund conditions should show as such.
So, okay, that'd be something you can send as a follow-up?
Yeah, at the next board meeting, the fund condition provided by our budget office, who I work closely with, will have those new numbers in there.
Okay, great.
Claudia Mercado, you had a comment?
Yeah, and also I would love to see how we're projecting maybe an increase in licensees, because I believe that is our main source of revenue for the board. And if we're following any trends, where we can get some updates on the trends as to how the profession is looking and how that's going to affect us. And or also, are we looking at putting together some efforts to make sure that we are visible to the public as a board and what we do and how that plays into the profession. I think that could help us increase our numbers, but I don't know, I'm just thinking more from a business perspective of who are our customers and why they're bringing us money.
Yeah, thanks, Claudia. I do address some of that in my executive director report that I will be talking about a couple agenda items from now. But yeah, you are correct. Our profession is growing, and our licensee totals are as well, which will affect these renewal numbers.
All right, if no other comments, we can move on to the
one more
next
comment.
item. Oh, sorry, go ahead.
Well, and can we also see it, in terms of the age of our of the people that we license? How many do we predict are going to stop practicing as well?
Thank you for that, Claudia. I'll definitely look into that.
All right, great. Let's, any comments from the public on this item?
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, click on the Q&A icon on your screen, type comment into the text box and submit that to our panelists, or you may raise your hand by locating that hand icon that appears next to your name. And seeing no requests, would you like me to close the panel?
Yes, please.
It is closed.
All right, thank you. And we will move on to item number 7, which is the update on board rulemaking proposals. Mark, you present the report.
Thank you, Dr. Bahari and board members. So I'm going to update you on our board rulemaking proposals. We have 3 proposals that were approved recently, and we have 1 that's currently pending at the moment. I'll go over those. The first rulemaking proposal is the notice to consumers proposal. So the board adopted California Coda Regulation Section 1606. So this section required licensed osteopathic physicians and surgeons to notify consumers of their licensure with the board, how to file a complaint, and how to check on the status of the DO's license. So this proposal was approved by the Office of Administrative Law on June 8th, 2021, and it will become effective on October 1st, 2021, which is the end of next week. The second proposal was the postgraduate training license. This proposal, it amended section 1690 of the California Code of Regulations. It added a new fee for the board's new license type, the postgraduate training license. It was approved by the Office of Administrative Law and became effective on June 16, 2020. This regulation was important because when the new postgraduate training license was implemented, we actually didn't have a fee code in law nor in regulations to actually have the authority to collect the fee. So that regulation was important to get the postgraduate training license up and running. The substantial relationship criteria, that's AB 2138. This regulatory proposal, it amended California Code of Regulations sections 1654, 1655, and 1657 related to substantial relationship criteria and rehab criteria for crimes or acts considered substantially related to the qualifications, functions, or duties of a licensee. This proposal was approved by the Office of Administrative Law and became effective on May 17, 2021. The last one is the continuing education audit regulation. So this proposal, it amends CCR section 1635, 1636, and 1641. The amendments will align the CME cycle with the licensee's renewal cycle and will create a post-renewal audit for CMEs. This will streamline the process and reduce confusion with licensees over their CME cycle and their renewal cycle. There's definitely some issues with that. So the board is in the process of finalizing these documents and anticipates submitting it to the department by the end of this calendar year for pre-review. We're excited about that regulation package. Not only will it avoid confusion with licensees, it's going to streamline our process a lot and implement this post-renewal audit, which I think is going to enable the board to utilize more functionality within the BREEZE system and allow doctors to go online and renew their license almost instantaneously. So something that we're excited about. It'll allow us to create, to do better customer service for our licensees while at the same time streamlining the process on the back end. So we're definitely excited about that. And that concludes my presentation, Doctor.
Any comments from our board members? Not seeing any hands. Oh, Dr. Ptl.
Yeah, I'm pretty excited about the CME proposal. As a licensee, also, we're the doctors here are in a unique position where we also are reapplying for our license, and mine's coming up, and I was able to try out the online system. But yeah, I'm excited for the progress that's being made, and I look forward to these changes. It's always kind of sad when this process is described, by my work as a cumbersome process. So they will email us when we're about to be, up for renewal, and I don't want this to be a cumbersome process, and I think this is a good step in the right direction.
Ms. Mercado, Claudia?
And also, I would love to maybe hear about what kind of benchmarks we're trying to hit with the rollout of the CMEs, and how often we're going to ask for feedback. 'Cause I think the more engaged we are with our users, the better we're going to be able to really see some good outcomes and or learn from them. Because I think we definitely have to start focusing on how we can be more efficient with technology. So this could be a good case study of how we rolled it out, and how we captured feedback and how we made improvements.
Thanks, Claudia. I'll definitely keep you in the loop.
Mark, I just had a question in general, and I might get asked this by other licensees, but I was wondering myself, if I submitted an online renewal, but then I got a paper renewal, do I just have to wait for the online to go through? I was just a little confused, and I know that some other licensees might have those questions too. That might help me better answer that.
So you're asking if you complete your renewal online, but then you get a paper one in the mail?
Yeah.
Oh yeah, so the paper ones are automatically generated. So if you submit it online, there's no need to submit the paper one.
Got it. Thanks for clarifying that.
You're welcome.
Okay. No other comments from board members? So we will move on and entertain any comments from the public on this agenda item. Moderator, any public comments at this time?
This is the moderator. We have opened the Q&A panel. If you'd like to comment on this item, please click on that Q&A icon on your screen, type comment into the text box, and submit that to our panelists. You may also raise your hand by locating that hand icon next to your name. And seeing no requests, would you like me to close the panel?
Yes, please.
It is closed.
Thank you. And with no additional comments, we'll move on to agenda item number 8, the Executive Director's Report. And that's Mark Ito again.
Thank you, Dr. Bahari and board members. So I'm going to be presenting the Executive Director's Report. I'll be going over licensing, staffing. I'm going to give a strategic plan update and a COVID-19 update. And then Corey Sparks will be presenting our enforcement report at the tail end of this presentation. So let me go over licensing first. So the first few tables I have there, that is our licensee population as of September 9th, 2021. So I've added a few charts from our previous board meetings. I know on our previous ones, I just had the osteopathic physician and surgeon table for our licensed population, but I've also added the postgraduate training license and the fictitious name permits. So for osteopathic physicians and surgeons, we have a total of 12,446 licensees under the board's jurisdiction. And out of those licensees, 9,755 of those are practicing or residing within California. Now, just to put it into comparison, I pulled the numbers from 2016, which is 5 years ago. And for our full licensure for those osteopathic physicians and surgeons, we had about 9,000 in 2016. So we have grown about 3,500 licensees in the last 5 years, which is a lot of licensees. It shows that the profession is growing, And what I don't have in the report is but I will say is that California has the largest population of DOs in the nation at 12,446. We have 997 postgraduate training licensees. The postgraduate training license became effective on January 1st, 2020. And we assume that all of those are practicing or residing in California, as one of the prerequisites of getting that license is that you are in a residency in California. We have 1,124 fictitious name permits currently, and that makes for a total of 14,567 licensees or permits that are under the jurisdiction of the Osteopathic Medical Board of California. So we are growing, and we're excited about that trend. The next table is our licensing workload. So the table shows our workload from fiscal years 2021 and 21-22. For fiscal year 21-22, there's not a lot of data. It's from July 1st to August 31st. We're so early in the fiscal year, but I did want to show you that data and kind of what it looked like. The number of days to approve a application currently is 88 days. For complete applications, meaning applications where we weren't waiting for any more information, that were submitted complete. And for applications with missing documents, it took an average of 123 days to approve. And an incomplete application is an application where we're having to send letters out to the applicant, wait for that information to come in. So a lot of that's out of our control of when those documents do arrive in the office. So that's the differentiation between those two application types there. So the license load for 2021, we had 699 DO applications received and 554 that were approved. And we issued 575 DO certificates. Now that number is down from last year, but there is a reason for that. The decrease in the applications is due to the implementation of the postgraduate training license on January 1st, 2020. So a lot of these licensees, there was a time where if you waited till January 1st, 2020, you'd be required to get a postgraduate training license. But if you submitted all your information before January 1st, 2020, you can get a license without having to do that. So we had a big increase in those applications last year, which made for a decrease in this year, but we anticipate that total jumping back up when these totals are run at the end of this fiscal year. For Ptl applications, we had 587 last year, and we approved 624. The reason that there were more approved than received during this fiscal year is because some of those Ptl apps were received in the prior fiscal year, and they were approved in the current fiscal year. We renewed 5,683 licensees last year, and I can say for the years that end in an odd number, we have more licensees renewing than those who renew in a year that ends in an even year. So next year our numbers should go down a little bit, and we anticipate them going up the year after. For fictitious name permits, we received 141, we approved 97, and we renewed 700 fictitious name permits during fiscal year 2021. So moving on to staffing. So the board has 13.4 authorized positions, and we currently have no vacancies. This is the first time we've had no vacancies since I became the executive director. I'm excited about it. With full staff, we're not going to have to redirect resources from other mission critical areas to get things done. We'll be able to, I think, lower our timelines and provide better customer service moving forward. So on September 1st, the board fulfilled its vacant staff service analyst position that is responsible for processing the more complex license applications for the board. And the board hired a new office technician to process all of the cashiering functions, and we were just waiting for a start date for her to start, and then we will be fully staffed, and that's something that I'm really excited about. I know there's been some issues with processing times because we've been redirecting, and without having to do that, we will be able to lower those processing times and fulfill our mandate of protecting the public. So moving on to the strategic plan update. So the board's 2019 through 2023 strategic plan was adopted by the full board in January 2019. Part of that strategic plan, there's goals. There's 5 goals. The first one is licensure. And as part of that goal, the OMBC requires that only qualified individuals are licensed as osteopathic doctors. There's an enforcement goal, which is to protect the health and safety of consumers through the enforcement of the laws and regulations governing the practice of osteopathic medicine. There's outreach and communication, and that's consumers and licensees are able to make informed decisions regarding the safe practice of osteopathic medical services. The fourth goal is regulation and legislation, and that's to monitor and uphold the law and participate in the regulatory and legislative process. And the last one is board administration, and is to build an excellent organization through proper governance, effective leadership, and responsible management. Now, as part of those 5 goals, there were specific objectives that were voted on, and the board has been able to fulfill a number of those goals, and we're still working on fulfilling the others. So I prepared a list of the objectives that we have fulfilled since the strat plan was adopted, and I'll go by goal. So for the licensure goal, objective 1.4, which is to align the continuing education audits with the renewal process to reduce confusion among licensees. I spoke about that during the regulations portion of this board meeting. So that is a regulation that is in process. We're excited about it. It's going to align the CME cycle with the renewal cycle, among other things in that regulation. So we're excited about that. Objective 1.6 under licensee is to research the feasibility of hiring additional staff to improve office efficiencies. The board is now fully staffed, and we hired a temporary staff to alleviate the backlog in the licensing unit. The board plans on requesting additional staff through the annual budget process next fiscal year. So next spring, when the budget change proposal process comes out, that is something we are going to look into, and we will request additional staff. It will be covered during the legislative report, but as part of Senate Bill 806, which is the board's sunset report, we are going to do a legislative BCP to gain additional staffing for that bill. So for the next strategic goal, which is enforcement, objective 2.1, which is to create efficiencies with the board's internal investigations to reduce case aging. The board's enforcement unit is fully staffed. We have focused on cross-training the complaints and discipline units. The board's enforcement processing times are within the appropriate time frame with the exception of complaint intake, and that number is going down, and Corey will cover that during his report. But the board is also optimistic with the additional staff that the intake processing times will go down, and that our processing times as a whole will be will look very good moving forward, and will meet our mandate of protecting the public. Objective 2.4, which is to research technological opportunities to improve workflow, efficiency, and communication between staff. The board's Assistant Executive Director, Terry Thorfinson, has been consistently communicating with the department's OIS unit to create efficiencies by ensuring that the board is utilizing all the capabilities of the BRE system. Specifically, the board has been implementing new enforcement codes to better utilize the tracking features within the BRE system. The next strategic goal, which is outreach and communication. Objective 3.2 was to develop presentations and informational videos to explain the application process and provide stats on the resident population. So the board created a PowerPoint presentation and frequently asked questions regarding the application process and the implementation of the postgraduate training. The board's executive director and the board president at the time, Dr. Zamuto, We conducted presentations on the application process and the postgraduate training license at the Osteopathic Physicians and Surgeons annual meeting in early 2020. Objective 3.4, which is to recreate the branding and logo of the board to better market and educate stakeholders. The board, in consultation with the DCA design and editing unit, they were awesome for us in creating this new logo we have, and this new logo was approved by the full board at its June 2019 board meeting. Objective 3.6, which was to attend schools, conventions, and other outreach events to be proactive in informing the public and potential licensees about the board. I attended several outreach events that included the 2020 OPSC annual meeting, the OPSC town hall meetings, and presentations with osteopathic schools in California to educate them on our application process, the new license type, and to answer any questions they had, just to be a face of the organization and to inform them of anything they needed to know. So the next one is Objective 3.7, which is to audit the website and develop content to keep it up to date, innovative and informative, and to drive stakeholders to the website. Me and Machiko Chong, my assistant, we worked in conjunction with DCA to update the website to make it more user-friendly and easier to navigate. We've been working on the website with them, and we're anticipating that it'll be rolled out by the end of this fiscal year. Goal number 4, which is regulation and legislation. Objective 4.2 is to explore hiring a consultant or pursuing a dedicated staff person to better track regulations and legislation. So in consultation with my assistant executive director, we've been having conversations about this, and we plan to submit a budget change proposal during next year's annual budget process for this dedicated staff person. Goal number 5, which is board administration. Objective 5.1 was to research options available to collaborate and utilize Solid to assist in creating a more cohesive team. So board staff attended Solid's True Colors class. This class helped staff understand their personality traits as well as their coworkers' personality traits. The class was a good team building exercise for the board. Increasing morale and building a strong culture is important to me. It's an ongoing process, and the board plans to use Solid for more classes moving forward. Objective 5.8 is to develop a board member orientation packet to provide to new board members during onboarding. So the board created a board member orientation packet in August 2021. The board onboarded its most recent board member, Denise Pines, on August 25th, 2021, using the onboarding packet we created. It was our first go at it. After doing some research, I discovered we had never done an orientation packet. So this is going to kind of be an evolving thing as we go, kind of making changes to the packet and improving as we go. But we do have a packet for now. So moving on to the COVID-19 update. I've kind of covered most of this at prior board meetings, but I'll kind of briefly go over it. So on March 19, 2020, the governor issued Executive Order N33-20, which provided a stay-at-home order for the citizens of California, except those that were needed to maintain the continuity of operations. The board determined that all staff at the board were considered essential. So I created a hybrid telework schedule that ensured staggered office visits and that we were able to be in compliant with the COVID protocols as set forth by the Department of Public Health. And this required staff to intermittently work from the office while maintaining the appropriate social distancing guidelines. Additionally, on March 30th of 2020, the governor issued Executive Order N39-20, which authorized the director of DCA to waive any of the professional licensing requirements and amend scopes of practice in Division 2 of the B&P Code. So the waivers that were issued that were instrumental to us, I can't thank the department anymore that these waivers went into place. The first one was the continuing education waiver. It's DCA 21-175. It's for active licensees that expire between March 2020 and September 21. They were temporarily exempt from completing or demonstrating compliance with the CME requirements in order to renew their license. That was the first waiver that was instrumental to us, and it really helped get the licensees back in the field while assisting the board with processing on the back end of this. DCA waiver 21-187, which is the reinstatement of licensure. This is for inactive licensees who are seeking to reactivate their licenses. They're temporarily exempt from completing or demonstrating compliance with any continuing education requirements. Additionally, they did not need to pay any fee to reactivate their license. The intention of this waiver was to get doctors back in the field to combat the pandemic. So the two other waivers, DCA 21-168 and DCA 21-167, it extended the time for doctors to obtain their postgraduate training license. So the board appreciated those waivers, and it allowed those doctors a little more time to get that postgraduate training license. So the last thing I want to cover, and it was covered a little bit in the DCA update, is the date has changed. So beginning September 30th of 2021, any state employee that has not been verified as fully vaccinated for COVID-19 must get tested weekly in order to work in the office. And as mentioned before, DCA has been instrumental in assisting the board through this process. I couldn't thank them anymore. Kim and her crew in the executive office have done a great job for us. The board staff that are not vaccinated will utilize DCA headquarters as their testing location. And just to kind of expand a little more on that, is that since we've deemed that all of our workers are essential, everyone's teleworking at this time, so everyone's spending some time in the office. So everyone on my staff who is not fully vaccinated or hasn't provided proof of full vaccination will require to be tested in order to work in the office. So that concludes my portion of the executive director's report, and I will pass it to Corey to do the enforcement portion of the report. Thank you.
Well, hello, board members. Can you all hear me?
Yes, go ahead.
Okay. I will go over the enforcement report. Do we all have a copy of the report in front of you? This should, I'm going to summarize this report. Basically, our enforcement report is going to cover the fiscal year 2021. This will be from July 1st, 2020 through June 30, 2021. So looking at our intake, data table 1 on page 1, we can just see that we've had, during this period of time, we had a little over 600 complaints that were received. Of those complaints, 676 were assigned, and the average date to intake those cases were 37 days. So that's high. The aging is high. We were trying to get that down. I'm going to go over that more when we get to the performance measures at the end. So of those initial 606 cases we received, 34 of those cases were convictions or arrests. And looking at the line graph in the middle of the page, figure 1.1, we can see that during the first part of this fiscal year, from July to December, our pending cases were really high. They were up around 150, then they went up to 100, and then they've gone down in January. And we've been able to, since January, really level off all of these, our pending cases and our assignments to around 50. So average around 50. And this was due to the fact that we've hired a new enforcement analyst that came in, able to bring those cases down and stabilize our intake. And moving on down to table 2, desk investigations. During this time, we assigned 674 investigations. We completed 571 cases. The aging to complete our desk investigations was 123 days. And at the end of June, we had 292 pending cases. That's the 193 that shouldn't be there on the totals. Anyway, so 123 days is really good in terms of our completion of our desk investigations. That's a little over than, a little over 3 months, which is really good. And if we go to page 2, we can see the our figure 2.1 desk investigations monthly totals. We were averaging pending probably for this period of time around 300 cases. And then if you see in October, we had that jump in assignments and jump in completed. That's what we addressed. We were addressing all of our cases in intake that had been backlogged. So we were able to really jump on that and bring those intake cases over into investigations and level off that problem. Going to our field investigation cases, these are cases that basically are very serious cases that need to be sent out to sworn investigators. During this period of time, we sent out 39 cases. We completed 36 cases. The aging for these cases was 621 days. That's a little under 2 years. At the end of June, we had 59 cases that were pending. So in the pie chart below that, you can see the breakout of these types of cases that we send out to the field investigators. 11 of those cases were prescribing, about 31%. 4 cases were unprofessional conduct. 8 cases were sexual misconduct. 3 cases were criminal. 3 cases were fraud. 3 cases were negligent or some kind of serious injury. 3 cases were substance abuse, and there was 1 unlicensed practice. Okay, moving on to page 3 of our report. Matrix of all investigations. So when we look at our desk investigations and our field investigations, we want to look at, the period of time it took to complete those cases. So the first 90 days, we completed 255 cases. From 3 months to 6 months, we completed 122 cases. From 6 months to a year, we completed 121 cases. 1 to 2 years, we completed 43 cases. And from 2 to 3 years, we completed 22 cases. I think what's important, we look at the pie chart, we look at that the majority of our cases are completed within 1 year. So that was 377 cases, or 67% were completed within 6 months. 498 or 88% were completed within a year. That's all of our investigations, both desk and investigation. Moving on down to enforcement actions. These are cases that we refer to the Department of Justice for disciplinary action. During this period, the board initiated 19 transmittals, 9 of which were accusations. I think of that 9, 1 of them was a statement of issues, I believe in the early part of the fiscal year. During this period of time, 13 final orders were filed. 5 of those cases were closed without disciplinary action. And we issued 3 citations, and we had 3 immediate suspension orders. PC-23s or ISOs. I think of those 3, I think that at the time, all of those were PC-23s. PC-23 is when someone does a criminal action, they go to a hearing, arraignment, we send an attorney in there and say, hey, judge, can we put a restriction on their practice? At the end of this period, there was 26 cases that were pending at the Attorney General's office. Okay, so moving on, looking at the aging, look on page 4, the aging for our final disciplinary actions. really, when we look at this chart and we look at the pie chart, really what we want to look at is that most of the cases that go to the attorney generals usually are within the 3 or 4 years it takes from the time we get it in the office to the time that order is finalized. So during this period, we had 8 cases that were completed within 3 or 4 years. We had a few cases we had one case that was closed 90 to 180 days, 2 cases that were 1 to 2 years, and 1 case 2 to 3 years. Typically, the cases that are closed really within a year or so, those typically are cases that are like out-of-state discipline, where we get someone from another state that was disciplined, we get the order. So the process to get that through the AG's office is typically pretty quick. Of these final orders, we basically had 9 probation, 9 cases, 9 licensees put on probation. We had 1 case that had a suspension included in the probation. We had 1 revocation. We had 1 surrender. We had 1 reprimand. Okay, moving on to page 5, we can look at our overall performance measures. And I want to look at our intake, our cycle time. So what we are now required now under the statute is that we have to send out a letter within 10 days of receiving a complaint. And prior, for previous years, the board was not really measuring this. We were measuring our intake 30 days, but now we need to track this 10 days. So as you can see, we are not really meeting this 10-day requirement for the most part in terms of our averages. We are bringing this down, as you can see in November, February, May, June. We are bringing it down. Since we've added a new analyst, another analyst, we are bringing it down. I think what I want to bring to your attention is that most of the larger boards have individuals in their staff that all they do is just intake. The complaint comes in, they intake it, send a letter. We don't have that luxury at this time. So all of our analysts, basically, once they get that complaint, they're looking at, I get the complaint, what actions do I need? What are the allegations? What actions do I need to take? What additional information do I need from the complainant? Is this within our jurisdiction? So they're trying to answer a whole bunch of questions at the same time once they look at that complaint. So it does somewhat hinder that getting this letter out within 10 days. But we are bringing it down. In fact, I ran a report for this September, up to September right now, our average is 9 days. So that's really good. So we are bringing it down. The average for July, August, and September is 19 days. And looking at that report, it's not in this report, but looking at those numbers, there's been a couple complaints that have come in that have kind of just somehow fallen through the cracks, and they all of a sudden show up, and we put them in the system, and it really affects that averaging. So anyway, this is our goal. This is our for enforcement right now. Our struggle is getting these complaints into the system within 10 days, and we're getting better at it. Performance measure 3, as you can see, we're really meeting the threshold. Most of our cases are completed. Each month, looking at these figures, well within 360 days. So the average overall is just under 200. So really doing well on performance measure 3. Performance measure 4, this is for discipline. Once these cases go out to the AG's office, it's really out of our control at that point, how long they stay at the AG's office. Many times what is a holdup on those cases or negotiation with the attorney, opposing counsel, trying to figure out what's best for that disciplinary action. So moving on to page 6, our last page for the report. This is just an overview of our probation. Currently, there's 40 probation cases. 3 of those are compliance monitoring cases. Those technically aren't probation cases. They're cases where we have reprimanded an individual, but we've added some terms and conditions like cost recovery or a course that they have to take. Of the probation cases, we've got 13 cases that are told. During the fiscal year 2021, 7 probationer cases were completed, closed out, 10 cases were open. The total cost recovery order to date is $516,000. We have about a little over $308,000 have been paid towards cost recovery, leaving a balance of almost $208,000. So overall, our probationers are in compliance for the most part. I would say 99% of them are in compliance. We do have a few, one in particular that is not. And so that is something that has been brought to our attention and we are working on it. So that is my report. And is there any questions?
Thank you, Corey. Are there any questions from any of the board members? I've got Denise Pines.
Hi. So this was a lot for me to digest in this, sort of between when I got the documents to now. So I want to start with the intake and the 10 days and how we're going to get there with the fact that you don't have sort of a dedicated person to receive that intake, whether they're calls or emails or whatnot. Like what's the plan? I mean, I've heard you talk about it got better, but numbers are all relative to how you measure, right? So yeah, they look better right now. And that could be that we only had, 2 complaints that came in the month of September. But so what is the plan of getting to 10, the real plan? What's the real plan of getting to 10 days? That's my first question.
Honestly, Denise, we've been experimenting with the staff and how to do this because it's, as an analyst, there's, an intake person, let me explain to you, an intake person is a processor. They're just processing the complaints and they're not really thinking about what the allegations and what has to be done. So, but we don't really have an intake person. Our analysts are analysts. When they get a complaint, they're looking at it and reviewing it. Now, I've talked to the analysts and they're basically, at this point, what they're doing is taking time off from, taking the thinking cap off their head from being an analyst and attacking the cases as they come in and putting them into the system. That's what they're attempting to do now. And so it's a matter of right now what they're having to do is kind of to juggle that and to try and set aside a time and do that. One of the things we've talked about in the last enforcement meeting was maybe to have one person a week just do the intake. There's 3 analysts, maybe this week analyst 1 does it. That was one idea that we've so that's
Is it so with the analysts, do the analysts have do they split the alphabet? So how does I guess I need to know how the analysts work in this instance, because I don't know how the analyst works in this instance. So
yeah, I can't answer that. I don't think an alphabet would be a good way to go with the intake because it's not. I think that if you do it that way, then what would happen was you'd have an imbalance of caseload for staff. They wouldn't have a balanced caseload if it was because it's just random at who is what complaints come in on a particular doctor.
Hey, Corey, I'll chime in.
Okay,
Denise
okay. So what I'm trying to understand is I'm trying to understand the current process, right? I'm trying to understand. I make a complaint, it comes in, and then what is the process internally like that? So we can understand how it's 49 or whatever the days are, and how do we get down to the 10 days that's being required.
So
Well, the complaint comes in. The complaint comes in to the office, and it immediately comes in. It's state stamped. There's a date stamped on that as we receive that complaint. And then once it goes to an analyst, the analyst puts that data into the Breeze system, and there's a date that they enter that into the system that measures the time that the receive date. So they have to put the receive date into the system. Either that complaint comes in online or it comes in through an actual physical complaint. And so then when they put in the data, usually it is a code that they put into the system. It's called an ASO1, which means that date, when it's put into that, the analyst gets it, it measures the period from the receipt date to that ASO1 code, which means it's been referred to investigations. So it measures that period. That's the intake period that we're trying to reduce. And so then once the analyst gets it, they start working that complaint normally like a complaint. That's been our normal process. We've never had a dedicated intake person. All of our analysts simply get the complaint, put it in, and immediately start working the complaint. Either they need a medical, either the complainant needs a medical, we need to get a medical release from the complainant, or if that's there, then we need to get the medical. If it's a quality care case, it's the medical records. We need to get the medical records, and we've got to send out that request to the hospital, or depending on the complaint, all we need to do is contact the respondent and get a response from them. So the basic general intake is, we get it, it's timestamped, we put this code in the system, that measures it, And so I think the analysts are struggling with, because once they get the complaint, their natural tendency is to start working the complaint. And by doing that, that takes up time. Whereas if we had someone, or like the bigger boards who just haven't someone just doing the intake, they just get the complaint and put it into the system. And so, we're asking kind of our analysts to do both of that. So that's kind of where we're at. Go ahead, Mark. I'm sorry. Go ahead, Mark.
Hey, Denise, this is Mark. Yeah, so we actually have kicked around the idea of the alphabet and having a dedicated intake person. But at the end of the day, as Corey mentioned, we're at 9 days now. We are fully staffed. We did have a missing enforcement staff for the majority of that fiscal year where we were behind. And now that we're fully staffed and we have it down to 9 days, I had an enforcement meeting with my staff, and if we can keep it at 9 days while we're fully staffed now based on our current process, then we'll keep doing it. But I said, we're going to reassess it every 30 days. And if we need to have a dedicated intake person, like a revolving person every week who's doing it, or we've also talked about just splitting up the alphabet for complaints as a whole. And we haven't done that yet because outside of our intake, our enforcement processing times look good. So I haven't done the kind of the big alphabet change at this point. But it's something that I'm going to reassess every 30 days now that we're fully staffed, to ensure that we stay within that 10 days, because we're there now. So if it's something where we can't maintain that, then we're going to look at alternate means to make sure that we are.
So on licensing, I don't know if anybody else has anything on licensing before I move on to enforcement.
Can I make a comment on Corey, or are we moving to the next?
Yeah.
So just to clarify, so the intake is considered when the lead, in this case, comes in for wrongdoing, right, a complaint, and it's just a timestamp. Is there any way to integrate the Breeze program where you're connecting like an API integration to our website? Because I'm assuming that's where the majority of the complaints come from. Because I'm just wondering, why do we need a physical person to timestamp things when we can potentially do an integration? And then it sounds to me that the analyst assign a code within metric to then put it in a bucket, like a location of where it belongs based on its category. I really see us working with Breeze and maybe implementing some updates there. where we have the system kind of thinking for us and keeping track of dates and maybe set some alarms or some systems to alert us if things are not going well. Because I think we should try to aim to be at 5 business days. That's just my feeling. And if potentially we could do that, that'd be great. I'm done speaking.
Well, in response to that, Claudia, the idea of because we get complaints both online and physical complaints. People just physically send us a complaint, and that's not in the system. We have to put that into the system. The idea of the measuring the aging from the intake to the ASO1 is basically to force us to look at that complaint and get to work on it ASAP and not to let it sit there. And so it's basically the reporting is telling, is saying how quickly did a physical person actually respond to this complaint. And that's what we have to.
And how many hours per, I mean, basically if you were to get some averages of how many you get in through these channels, what's the time that it will take for somebody just to put them in the system? Is it just relevant on the case? Or can you put like a timeline 2 to 3 hours a day?
Oh, I don't know that. I mean, if we're getting an average, you would think if you're looking at our intake received, we're getting roughly, 50 to 60 cases a month.
So yeah, I would suggest maybe looking at that data of the influx of cases and maybe, time. So then, you guys can think about allocating the right resources when we need them, if it's alphabetically or just, if it's 5 hours a week and somebody gets it done, then there's time allocation for that.
Right. No, I know exactly what you're talking about. Right.
Okay.
Yeah.
But I think it's a work in progress, but from when I joined the board, we've done a really good job bringing that down.
Yeah, it is a work in progress. We are. It is a high priority right now for enforcement to bring this down. And
Corey, can I interject just really quick? So this intake, when do we send a letter to the complainant or a recognition to the complainant that we've actually received and it's moving through our system? Like, how long is that taking?
well, that's what we're talking about. That's the 10-day, the date.
Okay, before they get a recognition that.
Right.
Okay. Okay.
Yeah. So it's, some boards have an actual code. We in our previous system we actually had a code for that letter, but we don't do that. We just have this ASO1 code, which is basically saying that the analyst has got the complaint, it's been referred to them, and we've started to work on it. So that code is actually measuring that intake process for us. And so, in that process, we have to send that acknowledgement letter within the 10-day. So that's where we're at in terms of, so that's why I say other boards they've got more resources and staff, and they can just have somebody sit there all day and do it. That's what they do. But our analysts they're AGPA, so they have much more on their plate in terms of looking at a complaint and working with that complaint and figuring out how to solve the problems of those complaints. So they got to do it pretty much from cradle to grave internally. So I think it's something as our complaints continue to grow, which they do. I think maybe there's a 5 or 10% increase each year of complaints that we may need to have someone. Just that's probably at this point I don't think we would need someone full time, but I think at some point if we had someone in the near future that's what part of their job was, that they just well, at this point, we're fully staffed and we're trying to meet that as best as we can.
This is Claudia, and I think it's important for us to start measuring time then, Corey, just so that we start really measuring how long this is taking the board or each person doing it.
Yeah, I have reports in Cognos. I can measure each person. I have averages for the actual analysts, but it just takes one complaint that somehow gets sidetracked that can skew those numbers. In fact, there are a lot of complaints. I would say I don't know how many complaints they are, but I mean there's probably a 15% cases or 20% of cases that actually are sent over to the Medical Board of California. So they're sent there and then they forward it to us, which I'm not sure if that's extending that time period. But I know when those cases go out to investigations, the investigators, when those cases come to the statute of limitations, those cases are measured from the date that the complaints are received at DCA. So if they were received at the medical board and the medical board, say, took 2 weeks to send it to us, then that's 2 weeks of time that our board didn't get a chance to look at that case. So, I mean, I don't know what that percentage of cases are, but there are cases that happens. So.
I have a couple other questions. I didn't see, do we do ISOs in this year or any 805s in this year?
Yeah, we've done, I think, we didn't do any ASOIs in this last fiscal year. We've done 2 ISOs since then, but they weren't reported in this report. So we had 3 PC23 cases that we did last fiscal year. 805s, yeah, I think we get, I haven't really reported on how many in the past. I've never really reported on how many 805s we received. We typically don't get a lot of 805s. I think we get maybe 3 to 5 805s, per year. Not a whole lot, but I haven't really been tracking those for the board. And if you want me to track those, I can put those in.
Yeah, that would be kind of helpful, just for me.
Okay.
And then just our aging. So it looks like we have a timeline of 123 days, but then when it goes to HQIU, like it swells, like the timeline, like is massive. I mean, do you have any insight of why? I mean, because I know they're pretty well stocked with staff. I remember that there used to be like a staffing issue, always never having enough people retiring, 1,001 things around staff. And now that's not really an issue. What challenge, are there challenges there that you have? I'm just trying to understand like the age of the average age saying that it's 973 days. And I know that could be skewed by if you only have a couple cases. I mean, that still just skews your numbers, right?
When it goes out to the field, and we've gotten roughly 40 cases out there in the field. And so these cases are much more serious, much more involved. And 50% of those cases are prescribing cases. And these prescribing cases generally are what taking up a lot of time, because what happens is on a prescribing case, if we get excessive prescribing, we have to locate patients that will cooperate. Even if you have an anonymous complaint, we run a cures on a doctor, and it shows, hey, yeah, he's got several. He's way out of the departure of general prescribing, controlled substances. So we look at the medical consultant will pick out about 10 patients that are just kind of outside of the normal range of prescribing. Then when we send that case down to field investigations, they'll try to get about 4 or 5 of those patients, and they have to locate that patient. Usually they have to send them a letter and wait for that patient to respond, say, hey, are you willing to cooperate with this investigation? Then they have to get that, if that patient decides not to, they have to send out to another patient. So they have to get the cooperation of the patient to get a medical release, so then we can get those records. And if that doesn't work, then what we have to do is do an enforcement subpoena and go before the judge and say, hey, judge, we've got a serious issue with this prescriber. We can't get records from the patients, but we believe that we have enough evidence to subpoena these records. So that takes an extra, cost and time. But those prescribing cases are generally what's taking time. So, and there's been a couple of these cases where they're criminal. And once it goes to criminal, a lot of times if the DA is involved or if the district attorney is involved or whatever other agency is involved in, they typically tell us, okay, you need to stand down. And so we have to just not do anything. In that case, we usually close those cases pending investigation. And we've had a couple of those just recently just lose statute. And then we have to reopen them again if a criminal conviction is imposed or we need to take action. So I have to track those cases and try and keep on top of those cases. So those are the few things that I can right now just bring light to as to why some of these field investigations take time.
Yeah. How many of our cases are the AG's office involved in? What percent?
Not many.
Okay.
I think right now we have 2 cases.
Just 2, okay.
Yeah.
Okay.
2 or 3 cases, but not many. We really try not to get the AG involved. I usually talk to the investigator and say, hey, do you think we need a DAG on this? If it's a serious criminal stuff, then yeah, we need to get an AG.
Then my last question is on the cost recovery, that 208,000, is that past due amount or is that we're still in our process of collecting? I didn't understand that in the report.
Oh, but that's our balance due, right? That's what we're collecting. That's left that hasn't been received.
In this fiscal year.
No, that's up to date. That will be up to date.
Okay.
Current up to date. Yeah.
Okay. So there's not a past due amount. It's just this is how much the recovery was. This is how much we've collected. We still have this amount. We're still good.
Right.
Okay. Okay. That's all my questions.
All right. Thanks, Denise.
All right, any other board members with any questions?
Mark, I just had a quick question. I know we in the past talked about modifying the CME requirements for our licensing. Do we have any updates on that? Just wondering.
Yeah, thanks, Doctor, for that question. We do have an update. Terry will be covering it a little more in the legislative report, but our sunset report has that reduction. We talked about it in there, which is going to reduce it to 50 hours every 2 years. So that's in our sunset bill, and Terry will cover that a little more in detail then. But that is in. We're thinking that's going to get signed soon, and that'll be implemented.
Thanks a lot.
You're welcome.
All right, let's go ahead and move on then if there are no other additional comments from our board members. Is there any comment from the public on this agenda item?
This is the moderator. We've opened the Q&A panel. If you'd like to comment on this item, please click on the Q&A icon on your screen, type comment into the text box, and submit that to our panelists. You may also utilize the hand raise feature by clicking on that hand icon next to your name. Our first comment comes from Xavier DeLeon. As a reminder, you will have a 2-minute time limit. I've sent you a request to unmute your microphone.
Can you guys hear me?
We can.
Hi, my name is Xavier DeLeon, and I'm an advocate father here in Bakersfield, California. And I'm looking at the complaint intake chart. And I just wanted to point out that in the assigned and closed column, the 676, I just believe that those numbers can be misleading because it doesn't show exactly what cases are assigned and what cases are closed. It kind of just merges them together. So I believe that those numbers are just kind of misleading to the public. And that was my only comment.
Thank you. And our next request comes from Tracy. Tracy, I've sent a request to unmute your microphone.
Oh, can you guys hear me?
We can.
Okay, I'm sorry. This is a new format for me. I'm usually on the other board. I also want to, my name is Tracy Dominguez. I'm from Bakersfield, California. I'm advocate for Bakersfield and all over California. I'm sorry. I also agree that that chart is unclear. The complaints don't show where they're assigned to, or if they're closed, or if they're going to investigating. It's just misleading to the public, and there needs to be a little bit more transparency on where they're at. And pretty much, you know, this is my first meeting, and I'm looking forward to talking to you guys more. And that's all I have to say right now. Thank you.
Thank you. And our next comment comes from Michelle Montserrat Ramos. Michelle, I've sent a request to unmute your microphone. Michelle, are you there? I see that your microphone is unmuted. However, we're unable to hear you at the moment. All right, Michelle, if you could possibly type your comment into the Q&A box. You can access that by clicking on that question mark inside of a square that you can find on your screen. Should open a text box. You can type your comment there. At this point in time, I don't know if Michelle can hear us. And I do not have any additional requests for comment. How would you like me to proceed, President Bahari?
I'm sorry, I said we'll probably let's give her 1 more minute to see if she can get our audio working.
Okay. And Michelle, I'm going to mute you and request to unmute one more time to see if that has any effect on your microphone. Michelle, can you hear us? We are still not able to hear you.
Maybe if she can type something into the comment box to at least tell us that she's working on the audio.
Yes. Michelle, can you please access that Q&A feature on your screen? You can click on the Q&A icon and type into the comment box. Let us know if you can hear us. If not, unfortunately, we may have to move on. She may be typing
There's
as
some-
we speak.
Yeah, there's some comments from Tracy, I think, that says she's
Yeah.
trying to work on it, and hold on a sec. So we'll give it another minute or two.
No, Michelle, we cannot hear you. So if you could type your comment into the text box, then I can read it aloud. Again, Michelle, no, we cannot hear you. I will need you to type your comment into the text box, please. Michelle, you are unmuted from my end. I show that your line is unmuted. Again, if you can please type your question into the text box, otherwise we'll have to move on. And Michelle, if you are connected by computer and phone, using your phone for audio, you will need to make sure that both devices are unmuted. Not sure if that could be your issue.
It seems like it has her connected. It's the little headset on it. It means she must be connected via computer audio.
Yeah, that's what I'm
Move on.
assuming. She's muted. I'm going to request unmute one more time. Michelle, I see that you are again unmuted. And we cannot hear you.
Sabina, can you hear me?
This is, yes, I can hear you, Sabina.
Okay, thanks. I was just going to mention, why don't you provide the general email, or you can provide Mark Ito's email address in the Q&A, and she can directly email her comment to him, and we can move on.
I will do so.
All right. Okay, well, we tried to get that going. All right, well,
I will
Kelly, if
close
we
the
don't
panel.
have any. Shall we move on then?
Yes, I've closed the panel.
Oh, okay. So thanks for that discussion. We're going to go ahead and move on to the next item, which is item number 9 on the agenda, discussion and possible action on pending legislation. And Mark?
Harry Thorfinson, the Assistant Executive Director, is going to be presenting the the legislative report.
Okay, wonderful. We have Terry.
Hear me now? Hello?
Oh, yeah, we just got you.
Okay. I had my headphones on. I guess that didn't work. I've been experiencing poor quality with video, so I'm going to keep my video off so that you can hear me hopefully clearly. The ledge report. This is a crazy, crazy ledge season. I've never seen anything like it. We had a lot of changes that were last minute, some of which are major, mostly the ones that I'm going to go over last in our sunset bill. So I'm going to start on this list. Some of these bills did not make it out of the legislature, so I'm only going to cover the ones that did make it out of the legislature. So AB 29 did not. So the first one that was approved by the legislature en route to the governor is AB 105, the Upward Mobility Act. And this bill deals with making changes to the statutory wording about the requirement of the composition of boards and commissions. And while this is this does impact the board is not the appointing body. The legislature and the governor is. So these changes will be something that will direct the legislature and the governor in future appointments. And it appears that among the changes that they're making is they're wanting, I mean, the goal or policy goal here is to have the composition of the state boards and commission be broadly reflective of the general public. And I guess to that end, they felt the need to delete the words ethnic minorities or women and add volunteer members. And the idea with the volunteer members is so the boards can hear from underrepresented communities that are not necessarily defined racially, ethnically, or culturally. So that's a big change for that. We will see based on future appointments what that means for the board. Moving on to AB 107. This bill was making changes to requirements for veterans and particularly military spouses. They had two competing bills, and this bill, which I do need more clarification if it gets signed, but the way the bill was written, we're not included in the requirement to issue a temporary license to military spouses. There's a specific list of the boards that have to, and we're not on that list. But that doesn't always mean that we're not included. So that will be more, we'll need to probably confer with legal on the interpretation. But this is requiring other boards to issue temporary licenses to military spouses that meet particular conditions. Primary condition would be that they're licensed in another state, and the temporary license would only last for 12 months and then it would expire. So more on that, but for now, we're not listed in the bill. Okay, AB 356, fluoroscopy, temporary permit. This bill allows for the issuance of a temporary permit for fluoroscopy. This is a bill in the past the board has opposed. This bill came up in a different format, a temporary permit. The Department of Public Health is the one that oversees the issuance of these permits, so it remains to be seen whether this will be signed. Past bills were vetoed, so the change in this one was the temporary permit nature. Moving on to AB 359, physicians and surgeon licensure exams, and I would add CME. This is a bill I think I raised your attention because the first part of the bill deals with the medical board's exam try requirement. And the concern I had is whether we got added to the bill, which we did not. So the first part of the bill about exam tries doesn't apply to us. In the bill initially for the med board, the policy issue that I raised was this bill is trying to extend the number of tries that an applicant for a licensure, and in this case the med board, can take the exam. And from our perspective of our board, we rely on the national boards to determine qualifications, competency, evaluation, and number of tries. And so having the state step in and try to modify that would be something that if it had done it, we probably would have opposed it. But I guess we're thankful that it didn't include us. But what it did include is CME changes to the kind of CME content that are required. And this, I don't know, is a favorite subject of the legislature, probably because it usually doesn't cost money and changes or special subjects can be included in it. But the type of subject change in this bill was to allow for 30% of CMEs to be able to count in subjects non-clinical, like record keeping and kind of the practical aspects of having a practice, medical practice, or running a clinic, and that they wanted to change that and allow that type of CME would be allowed. And the downside of that is that the requirement of CME was always conceptually required to have some kind of insurance and a requirement that drives physicians to stay competent through doing a certain amount of CMEs. So those CMEs were originally tied to competency and clinical training. So now those CMEs have kind of been watered down on the clinical end. It doesn't mean everybody has to use those kind of CMEs, but now they're allowed to be used and counted to up to 30% of the total number of CME requirements. So moving on to AB 361, Brianna and I think Mark mentioned this. This is the open meetings law, different than in your board packet because, as I said, this legislation was crazy, and so things move very fast, but this bill did get signed into law contrary to what you have in your board packet. And so that will go into effect. And I guess the point that I can't remember if anybody made was that this bill extends the ability to have open meetings only until January 2022. After that, which is a little unusual, usually bills go into effect on January 1st of 2022, but this bill goes into effect immediately and ends in its effectiveness in January 2022. Moving on to, healing arts. Okay, AB 1156. This is listed as healing arts, medical school graduates, postgraduate training. This is a bill that I believe was sponsored by the CMA to change the license requirement for physicians and surgeons for both boards, medical board and osteopathic board. And they wanted to change the requirements from completion of 36 months of postgraduate training and that you couldn't be you wouldn't be eligible for applying for a full license until you completed those 36 months of postgraduate training and demonstrated to the board that you completed those with a notarized document signed by the director of the training program sent directly to the board. So it would be an original source document that could verify the truthfulness of that certification. So the change that they were proposing, I should say they are proposing, is to get rid of the 36 months requirement and allow physicians to be licensed or eligible for licensure after completing only 12 months of postgraduate training. Now, this bill, interesting, is a competing bill with the changes that I'll later go over in 806, our sunset bill. The changes in SB 806, which is our sunset bill that we share with the medical board, it also makes changes similar but not the same to the licensure requirements. And if I were going to speculate, the sunset bill, because it authorizes the medical board's continuance, I believe that one will be signed. And because of the competing nature of the bill, I believe AB 1156 will be vetoed, but there's no guarantees. The other thing that 1156 introduces is there have been issues that were raised within the sunset that said that the 36 or a certain month requirement for training conflicts with some of the labor laws that allows for trainees to take time off. And the time off would mean that, one, they're allowed to, and legally, and because they're allowed to, they would be essentially not completing the full number of months, whether it's 12, 15, or 36. And so that was a concern for us. And the other area that they wanted to do is they wanted to, instead of changing the training program director's certification of completion of a certain amount of months, they changed it to they are certifying that they're competent and they meet the requirements. So that change in language is kind of ushering in and trying to get rid of the labor law conflict that the specific months completion created, and allows for the training, kind of shifts the authority of the compliance of the months creation and competency to the training program directors to sign that they are competent and essentially have met the requirements of the statute. So let me go on to, let's see, AB 1236 did not make it out of the legislature, so I'm not going to go over that. AB 1278 did not make it out of the legislature, so I'm not going to go over that. So the next one that made it out of the legislature is AB 1477, maternal mental health. This bill requires that physicians that treat pregnant women include mental health screening and services to be offered to mental health women before and after their pregnancy. So it was a short bill. That's what that bill does. Moving on to the next bill, AB 1534, the California State Optometry Board. This was their sunset bill, but the medical boards, ours and the medical board, were mentioned in it because ophthalmologists are licensed as physicians and surgeons. So in making the distinction to changes of scope of practice within the optometry profession, who are not physicians and surgeons, our board was mentioned. We also added, our board was not mentioned in a lot of cases in this bill. So I had requested that our board get mentioned every time the medical board got mentioned in this bill, which came to pass. So that just added, that's the significance of that bill for this board. Moving on to SB 310, unused medications, cancer medication recycling. This was a program that originally was put under the medical board and would have been put under our board that made both of our boards very nervous staff-wise, because the expertise to run a program like this and to not only ensure that there's compliance with handling and storing medications, that we just didn't have that kind of expertise like the pharmacy board did. So both of our boards recommended that the pharmacy board was the better board to regulate this. And the concept that the legislators were trying to do was it came to their attention that in practice, there is evidently unused cancer treatment drugs. And so instead of throwing them away, they felt like, they're still good, and why don't you create a system where those drugs could be given to doctors and be used for patients that wouldn't otherwise be able to afford cancer treatment. Cancer treatment drugs are typically very expensive, so anybody that's uninsured, it may be out of their reach. And so this was trying to kind of create a win-win by leveraging free cancer treatment medication to those people that couldn't otherwise afford it. Although the main kind of public safety element to this was that while it's a good idea, it has to be done correctly, because these drugs, if incorrectly stored, could become harmful to patients. So that was one of the reasons that I think the legislature agreed it should be under the pharmacy board. So that is a relief that we are not regulating that program. Let's see, SB 731 did not make it out of the legislature, so that leaves SB 806, Healing Arts. This was our sunset bill, and I'm going to start with the good news. The good news is that we made it out of the sunset and are extended in terms of, in theory, our operation. We're not up for sunset until 2026. That signals that the legislature likes what we're doing and extends us. But in reality, just as a reminder, we are an initiative-created board. And so what that means is the legislature doesn't have the power to sunset us, technically. They only have the power to review us and regulate us. So the significance of that is that when they extend it, we should get the automatic extension. But if they wanted to review us, they could give us less time. So the signal for our 2026 is a good sign that the legislative committee that reviewed the board was very happy with what they found with the board. The other thing that was in this bill is, if you recall, the board approved requesting a change to our CME hours from 100 to 50 hours and in the cycle, and to change the cycle so that it is the same. So the expiration cycle of 2 years is the same as the CME cycle. Prior to this, it was not, and it's very confusing to, I think, licensees when they're doing their renewals, because it makes a difference when that CME cycle was. So the CME cycle in the current form would require completion of CMEs every December. If it's the second year of your licensure, every December 31st. After that, even though you may not, be up for renewal, let's say until September, you're not supposed to be using that period of time for CME completion. So we got rid of that, so it's the same. I think it's going to be simpler for the board, simpler for licensees, and it's a huge change and huge convenience, I think, for both, for everybody involved. The other aspect was reducing it to 50 in the 2-year cycles. We required 100, and I think the history of the 100, because the medical board requires 50, it's my understanding that there was, through the evolution of the Osteopathic Medical Board and the DOs integrating into the healthcare profession alongside MDs, we've come a long way in integration. But some of the earlier strife, I think that the board felt that DOs, they wanted to make sure DOs completed 100 as opposed to 50. And now I think there is, as you heard testimony at one of our prior meetings, is that there isn't really a difference. And when DOs are training side by side and one board requires 50 and one board requires 100, it doesn't really make sense. So that change got into this bill. So that one will be going into effect January 1st. Now what I would call the bad news is the changes to the license requirement. Similar to 1156, there was huge pressure, and I think the committee wanted to stay on top of being the one that made the changes. And so they adopted the change to essentially allow postgraduate trainees to have to only complete 12 months of postgraduate training, but they wanted to still retain that they eventually have to still complete the 36 months. So what they did was make them eligible after 12 months to apply for the physician and surgeon license. They shortened the postgraduate training time period from 36 months down to 15 months. And then when they come up for renewal, then in order to, what they call, retain their license, for those that are not licensed in another state or in California, they would have a full license. They would have to demonstrate to the board whether they have met the requirement of completion of 36 months of postgraduate training, 24 months of which have to be in the same training program. So those are kind of two requirements that were retained from the current, requirements, but they move on not in the applicant stage, but in the renewal stage. So the enforcement of this is going to be kind of tough, because what we're doing is we have one application for licensure, in the sense for a full license, but we're going to have two sets of applicants. One that are licensed in another state, those are reciprocity. That remains unchanged. Of the ones that are not licensed, either from out of state or in state, they will be eligible to apply for licensure effective January 1, 2022, to apply after completing 12 months of their postgraduate training. And then for implementation purposes, we are going to have to identify that population right away in January so that we can track them and follow up with them to notify them ahead of their renewal that they need to demonstrate completion of 36 months of postgraduate training. And the demonstration is the same kind of document they would have had to do currently with 36 months. They just would, the program creates, signs off on a certification of 36 months and notarizes it and sends it directly to the board. So they would have to do the same thing as a condition of renewal. Our board has a prorated system of licensure. We do licensure by birth date. And so the first licensure is based on trying to license the person from the date they're going to have their license issued to their birth date. And we have a calculation in our regs and also in Breeze that doesn't allow for issuing licenses before 12 months and more than 24 months. So this means that some of our people are going to come up for licensure sooner than they complete their 36 months. And some of them will come up for licensure after. They'll have to be renewed and licensed after the fact for the second renewal. So we need to, in both cases, be able to track which ones are due to have completed their 36 months for their first renewal versus who is not going to be done with their 36 months of postgraduate training at the time of their first renewal, but would have to demonstrate it at their second renewal. So I'm already working, I work closely with the medical board, IT staff and our IT staff on how this would be implemented in terms of Breeze. Unfortunately for both boards, a lot of this, Breeze cannot do all of the automation. A lot of this is manual. So as a result, both boards have requested additional staff. We requested an analyst level to be dedicated to tracking this. It's going to be kind of an electronic tracking system where we would add like a modifier that could be tracked, and we'd have to be doing queries in what they call Qbert database to identify people on probably twice a month so that we know which people are up for renewal by what date, and we can count out probably 6 months before. I'm also working on trying to get an auto letter, a deficiency letter that automatically gets sent to these people that would have to demonstrate this, so that we'd have at least one auto notification. The rest would probably be manual by staff. And that would be how we would track them. Once they've demonstrated that, they would be like any other renewal. If they fail to demonstrate, the legislature requires the board switch their license status to delinquent and require them to cease practice as a result. Delinquent status, in any case, like if a license expires, it automatically goes in delinquent status. Delinquent status requires a physician surgeon to cease practice until they're licensed. In this case, this could mean that they have exhausted, because the bill gives 60 days for them, for the processing for the board and the licensee to demonstrate and process this document for completion of the 36 months. So if they fail to do that, then the staff would have to manually change the license status to delinquent. And if later, at such time they do complete their 36 months, then that would change. Otherwise, they would remain delinquent for 5 years until their license is automatically canceled. There was some, I don't know if it's called interesting dialogue back and forth about how to deal with this kind of penalty if they don't meet the requirements. And initially they had a revocation in the statute, and that we said would probably create a lot of enforcement expenditures at all of the levels, potentially investigation, AG, and the court. And they didn't want that. They didn't want this to be an enforcement action. They just wanted to enforce that you can't retain your license unless you've met this 36-month requirement. So in the last days, and I'm saying the last days, because there were about 3 amendments within a week, they finally put in the final language that said that the penalty for non-compliance of completing 36 months is that their status would be changed to delinquent and they would need to cease practice. So that is how they are essentially changing the license to make it easier for physicians to get licensed earlier, but still retain the requirement of completion of 36 months of postgraduate training. I will mention, for those that aren't necessarily familiar with the history, is prior to our last sunset and years after when the postgraduate training license was created, the requirement for licensure was only completion of 12 months of postgraduate training. And at that time, we had no licensure and no jurisdiction over the first year of residency. So in creating the postgraduate training, it ushered in not only jurisdiction for the day one of the enforcement jurisdiction, that is, over day one of the residency program that was extended through the 36 months. Now we end up with this current proposed change so that we are still retaining, now we have jurisdiction from day one, but the postgraduate training license ends in 15 months or sooner, depending on if they get licensed, the full license. And then the full license, they're eligible to apply for that at 12 months. And then they have to demonstrate that they have actually completed the 36 months, otherwise their license status becomes delinquent. So that's in a nutshell what the new license change is, and it goes into effect January 2022. And so anybody that is applying for licensure before that will still, as a lot of laws, it still applies under the current rules. The new rules don't go into effect until the January 2022. So we're anticipating a real landslide of full licensure applications that we didn't expect. And so we are the most concerned and focused on making sure we have staff in place to be able to track and enforce this new 36-month rule largely manually, so that people don't fall through the cracks and just get licensed and we don't follow up with them. So I'm confident that we will be able to put in place a system that will prevent anybody from falling through the cracks. But I think it's going to increase for sure it's going to increase our natural number of licenses. And in the past, each change in the license law has created like this big surge of applications, particularly from out of state. When we did the postgraduate training changes, we had a surge of physician and surgeon license applications. People wanted to get in under the current rules of not being required to complete 36 months. Now it's going back to the 12 months. And so maybe we'll get a lot of residents that are from out of state applying. We'll for sure get the residents from in-state applying because they need to have a license, kind of continual postgraduate training in the first 15 months, 12 to 15 months of their residency, followed by the authorization to practice and continue to practice medicine within the residency would then be under their full license. And then because of the 36 months requirement to retain that after that residency, they would need to demonstrate that completion. Otherwise, they would lose their license essentially through a delinquent status. Any questions on any of the bills or that bill?
No.
Okay, thank you.
Claudia.
Okay.
Claudia has a question.
Thank you. Wes, I'm so sorry. I got disconnected for a second because I lost power. But SB 15, that's at the governor's office. Is that correct? Ready for signature?
Which one?
Maybe it wasn't listed here then. SB 15.
Oh, 15? No, it's not listed here. Which one? What is that?
Okay, yeah, that's what I thought. I was like, maybe I missed something, but I think there's a bill on the governor's office right now awaiting signature that maybe we can get behind, and it's I think it's by Senator Limon, and the idea is to have the boards report on the diversity within the board, and the idea there is to have boards and commissions that represent the different communities throughout the state of California, because I think until now that data was missing. So maybe we can look.
I think 105 has a reporting requirement. That is on our list. I went over that.
No, let me look up the other one. Let me 1 second.
Okay.
So 1 second.
And in terms of a reporting requirement, what's significant is if we control whatever the statute requires, then we are the ones that do the report. But since we don't control the appointment of the board composition, I don't know that it would be the board that would keep track of that. But it's unclear to me.
Let me clarify. I'm so sorry. It's SB 702. Can you guys hear me now? This is Sabina.
Yes.
Okay, thank you. Well, sorry, I had to change microphones again. I was going to remind everybody that we can only discuss the items that were agendized today. Okay.
So just to clarify, you said there was already one that you mentioned has a reporting on those numbers?
Yeah, I believe AB 105.
Okay, I'll look into that. AB 105.
Okay.
Thank you.
Other questions?
No, I don't have a question, just kind of a comment. Thank you. This was a really good summary of the bills and helping us to understand where they are and how they impact us. It would be also good just for me to, just because I'm kind of coming into this new, to know when you do the summary, if you could state what position, if in fact we took a position. You mentioned it didn't include us, but you didn't mention whether or not the board took a position. So if you could, going forward on when we talk about the bills in this summary capacity, is to let us know what position we took, just kind of reminding us whether we took a neutral, opposing, or a support position. That would be awesome.
Yes, Denise, that is something we usually include, but since the board did not take any positions, that's why our position is not listed. It's essentially neutral.
Okay.
And my interaction with committees was not to support or oppose things, but to give technical assistance from the board's perspective about how the proposed statutory language would impact the board that would be good or bad, when they're including our board, things like that. So none of that really constitutes a position. And in May is when the board typically takes positions on, and this year the board didn't take positions on any of the bills. But that's not necessarily true in the future.
Okay.
But so we would naturally divide these up by positions versus just watching or neutral.
Okay. Thank you.
Any other questions from board members this time? All right, is there any public comment on this agenda item?
This is the moderator, and at the direction of the president, I've opened up the Q&A feature for public comment. If you'd like to make a public comment on the agenda item of legislative items, please click on the icon with a question mark inside a square, located usually at the bottom right-hand corner of your WebEx screen. We have instructions on the screen for your reference, and in the text field, typically also in the lower right corner, type "I'd like to make a comment" or simply the word "comment," and we will take comments in the order received. And I do not see any requests for public comment at this time. Shall I close the feature?
Yes, please. All right, so we're going to move on, having no public comment on that item. Move on to item number 10 on the agenda, which is future agenda items. Mark, do we have anything that's supposed to be on for the future?
Yeah, thanks, Doc. I've taken a couple notes. I'm going to be including demographic information regarding our licensees in my executive director's report, and I'm going to add any positions if taken in my legislative report. But in terms of brand new items, I don't have anything jotted down at this point.
Okay. Denise, is that an old hand raised?
No, that's a new hand raise.
Go for it.
Okay. I would like, and I know this could be late to add for consideration, but just giving the way the legislative office wraps up and goes on holiday, if we can potentially look at our board meetings our September board meeting being in August to be able to make any last, comments, edits, support, whatever, on the final legislation that goes into final decision-making. It'd be great that we actually had a board meeting before that time frame, because now where we're at is we have 2 board meetings after that kind of legislative process. So like an August board meeting and then a November board meeting instead of a September, right? I think late November board meeting.
I don't know how people feel about, you're talking about taking like particular this meeting and moving it up a month?
Yes. To
And that's
align
in-
better with the legislative process. Like right now, we're not really aligned well with the legislative process and legislation that impacts us potentially, where we would not have, the board would not have a chance to weigh in and have any final input. Being able to make input way in May, as you know, those who are part of the legislative process, 1,000 things can happen literally the night before. So for us not to have a weigh-in for a long period of a stretch of time is I don't know, it doesn't feel right to me.
Yeah, in the past, when there have been lots and lots of legislative items that that required our opinion or our assistance in reviewing, we have had sort of ad hoc meetings where we have posted that there's going to be a teleconference going over the meeting at such and such, but it didn't affect the meetings that we had planned out from the previous year. That's a possibility.
This is Sabina. I think our next agenda item is going to cover our scheduling. Is that correct? Our calendar?
It is supposed to cover all the future meeting dates.
Got it. Okay, so we'll probably address it then. I don't know how far we calendar out, but this is just for agenda items.
Okay.
That's it.
Okay. If there are no more comment on additional agenda items from the board members, we'll move on to public comment on future agenda items. Oh, sorry, hang on.
Is there a way that we can also get a small review into how the website is looking? I think Mark mentioned that it's a work in progress. We'd love to maybe be able to give the board to give some input, or at least for us to get a walkthrough of what the process looks like for somebody accessing our website.
Yeah, that's a good idea.
Yeah, we can do that for sure.
Additionally, Mark, there was one, if you remember, one of the sunset items was making sure that our minutes get updated to the website I don't know what the time frame was, but we were a little bit behind on some of our old meetings, getting our minutes updated. And maybe just an item on the agenda to go over how we've made that improvement.
Okay. Yeah, those are up on our website at this time, but I'll go over that next meeting as well.
Perfect.
Yeah, thanks.
Dr. Patel?
I was gonna say that a walkthrough would be great, just because, like I said, again, as licensees, we kind of have to navigate the website, so it'd be good to kind of get our perspective too. I appreciate that.
All right. No other comments from board members? No, then we will move to public comment on future agenda items.
This is the moderator. We have, at the direction of the president, I've opened public Q&A feature for public comment. If you'd like to make a public comment on this agenda item, please click on the icon with a question mark inside a square at the lower right corner of your WebEx screen. And I see no requests for public comment. Shall I close the Q&A feature?
Yes, please. Okay, we will move on to the final agenda item before adjourning. Future meeting dates. So this kind of goes back to what Denise was talking about. But Achiko, are you on?
I am here. So we only scheduled out one meeting, which was we scheduled for January 20th of 2022. Typically we have another meeting in May. So I don't know if you want to stay with that month or if you want to move it up 1 month to April. I charted out the dates that are available on Thursday, unless you guys want to move it. Historically, it has been a Thursday that we hold all of the meetings. So depending on if you want to stay with May, I can give you those dates or provide you with dates in April.
Would that be sufficient, Denise, to have a meeting in May? Or do you still want one more before the October
One
one?
more. Yeah, I think we should have an April and then an August.
April and August. So
Yeah,
for
can I chime in? No, sorry.
Go ahead, Mark.
Go ahead, Mark.
Yeah, I agree with Denise and that we should probably have one in August, especially if we're going to try to be a bigger presence in the profession. And it's hard to take positions on bills if we're having a meeting so early than pretty much right when they're being enrolled. So I don't disagree with Denise in having that meeting in August.
I personally think that would be fine. If any of the other members have any.
That sounds like a good approach.
Okay, so April, August.
April, August. Okay. So for April, we have the 7th, the 14th, the 21st, or the 28th.
Let's see.
14th.
Maybe not the 28th because there's a FSMB meeting, I think, during that week or that day and weekend.
I would say not the 21st for me.
For me, anything but the 28th.
With me.
How about we do
April 14th sound for everyone?
April 14th sounds good to me.
This is Sabina, if that works, let me check in with your new counsel by then. I'm not available that day, but I'm gonna guess, I'm gonna check in with your new counsel to see if he might be available by then. Moderator, is Michael on the line still here as an attendee? Michael Knutz, can you unmute his microphone, please?
Certainly, one moment.
Thank you.
On April 14th.
We didn't hear the entire sentence, Michael, sorry.
I am available on April 14th.
So April 14th is okay with everyone? Yes.
Sounds good.
Okay. And then in August, you have the 4th, the 11th, the 18th, and the 25th.
On the 5th, if possible.
I think that would work for me.
Yeah, same here. That's fine.
Works for me.
The 25th. Legal counsel, is that okay with you as well?
He'll have to unmute his microphone again.
Yeah, yes, that's fine with me.
Why don't we, if anybody has any objection, I said, why don't we just keep it at those 2 days, give ourselves some flexibility for future dates because we'll have some understanding of kids' breaks and that sort of thing. Or did you want to try and schedule more? And there's one other one we have to schedule.
This is Terry. If I may, in the ledge season, 25th is kind of late.
Yeah,
Because in most seasons, that only allows like 2 or 3 days before bills have to get out of the legislature. So if the purpose
you
of
wanna-
the August meeting is weighing in, probably needs to be earlier than the 25th in August. as
Want
a
to try
suggestion.
like 11th or 18th? 11th?
18th, if we can do 18th.
Does that give us enough time, Terry?
Yes,
Michael, are you available on the 18th?
I'm available any day, any work day in August.
Are we in agreement on the 18th?
I think so. Anybody?
So April 14th and August 18th.
Okay. You want to just hold off on any additional dates after that for now? We can talk at the next meeting. And then Sabina, are you still on?
I am.
The meeting that board has to have about the executive officer evaluation, we have to discuss at some point.
Yes, we'll have to reach out to reschedule that. It's going to be between October and December.
Okay.
Well, we can reach out. You'll work with HR. We'll work with maybe send out a doodle poll and to try to schedule a quick teleconference or WebEx meeting to take care of that.
Okay. All right. I always forget this aspect of it, but I'm assuming we still do take public comment on future meeting dates. So if there's any public comment.
Thank you. This is the moderator, and at the direction of the president, I've opened up the Q&A feature for public comment. Look for the question mark inside a square in the lower right-hand corner of your WebEx screen and type the word comment and send to all panelists if you would like to speak about the future meeting dates. And I see no requests for public comment. Shall I close that feature? And President Buhari, shall I close the Q&A?
Yeah, yes. Can you hear me?
Yes, now I can. Thank you.
Oh, perfect. Okay.
Interview. We can't hear you.
I see Board Member Pines has her hand raised, but we're not hearing audio.
Terry, can you hear me now?
Yes, thank you.
Sorry about that. This is the perfect time to adjourn because my silly little earpods just died on me. Okay, so I was moving to the very last agenda item, which is adjourning the meeting. So we are adjourned at my computer says 2:49 in the afternoon on September 23rd. Thank you, everybody. It was very nice seeing you again. Welcome.
Thank you.
Denise.
Thank you.